First of all, ladies and gentlemen, we make a humble request to all our esteemed dignitaries and participants to kindly keep your mobile phones in silent mode so as to maintain the decorum of the conference. Isa-isaga loinabirakpa mobile phone sing adu silent mode natraga vibrate mode thambinabagidamakta ahanbada nolukchari. As the respected Chief Guest and Honorable Chief Justice, High Court of Manipur is arriving here shortly, would like to request everyone present here to keep your mobile phones in silent or vibrate mode to maintain the decorum of the event. Ladies and gentlemen, at the outset, may I humbly request all to kindly rise and accord a respectful welcome as we have the gracious arrival of the Honorable Chief Justice of the High Court of Manipur, Mr. Justice K. Somashekar, accompanied by the Registrar General, High Court of Manipur, Shri Ojis Mutum. Ladies and gentlemen, please welcome once again Honorable Chief Justice, High Court of Manipur, and all our respected dignitaries who is taking the chair as our Presidium member of this auspicious occasion. Ahanbada Lingshin Biriba Kwaipum Namokpu Ikoknona Kurumjeri Namaskar. Respected Honorable Chief Justice, esteemed justices of the High Court of Manipur, dignitaries on and off the dais, distinguished members of the legal fraternity, learned invitees, uniformed personnel, ladies and gentlemen, good morning and a very warm welcome to this two-day state-level conference on Nd&Ps Act, cybercrime and 3 new criminal laws organized by the High Court of Manipur in collaboration with the Manipur State Legal Services Authority and the Manipur Judicial Academy. It is indeed an honor and privilege to have in our midst today some of the most eminent legal luminaries and policy shapers of our time. This august gathering reflects our collective resolve to understand, deliberate, and engage with the pressing challenges of law enforcement, cyber jurisprudence, and the recent transformative changes in our criminal justice system. Along with the Honorable Chief Justice, joining us today are Honorable Mr. Justice A. Bimol Singh, Honorable Mr. Justice A. Guneshwar Sharma, Honorable Mrs. Justice Golmei Gaiphulshillu, Shri Lenin Singh Hijam, Shri H. S. Brajabihari Singh, Shri N. Kumarjit Singh, and Shri C. H. Bimol Chandra Singh. We shall now proceed with the felicitation of dignitaries as a gesture of our profound respect and acknowledgement of their esteemed presence. So first of all, would like to request Shri Ojes Mutum, Registrar General, to do the honor of felicitating our respected chief guest. Presenting a token of appreciation, a traditional stole, Lingyan, as a deep respect and gratitude. Thank you very much. Next, we'd like to request Sri Alec Muiva, Member Secretary, Masalsa, to do the honor of felicitating Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur. Thank you very much, sir, for gracing us. We welcome you once again. Thank you. And next, may I have the privilege to invite Shri M. Manoj Kumar Singh, Joint Director, Manipur Judicial Academy, to do the honor of felicitating Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur. We welcome you, sir. Thank you very much for gracing us. Thank you once again. Next, may I have the honor to invite Shri K.S. Ajit Singh, Registrar Judicial, to do the honor of felicitating Honorable Mrs. Justice Golmei Gaiphulshillu, Director, Manipur Judicial Academy. Thank you very much, ma'am. We welcome you. Thank you so much. And next, we'd like to request Registrar Admin Sri P.H. Japan Singh to honor and felicitate Advocate General, Government of Manipur, Shri Lenin Singh Hijam. Thank you very much, sir. We welcome you. ngasigi thoram asida taramnok chari. And next would like to request Srimati Mona Lisa Maibam, Registrar Vigilance, to do the honor of felicitating Shri H. S. Brajabihari Singh, Chairman, Bar Council of Manipur. Chairman Busu, Nasigi Thorumasida, Taramno Cheri, Ikaikumnaba Ucheri. And next would like to request Registrar Translation Wing Shri K. Nirochit to honor and felicitate President High Court Bar Association of Manipur, Shri N. Kumarjit Singh. President Buttaramno Cheri Ikaikumnaba Ucheri. And last but not the least, may I have the privilege to invite Ms. Sarungbam Mangalebi, Joint Registrar Judicial, to honor and felicitate Sri C.H. Bimol Chandra Singh, President, All Manipur Bar Association. Thank you very much for doing the honor. To set the tone for today's deliberations, I now invite Shri Ojis Mutum, MJS Registrar General High Court of Manipur, to deliver the welcome and keynote address.
Respected my Lord, Mr. Justice K. Somashekar, Honorable the Chief Justice, High Court of Manipur, and my Lord's companion judges, Honorable Mr. Justice A. Bimol Singh, Judge High Court of Manipur and Executive Chairman of the Manipur State Legal Services Authority, Honorable Mr. Justice A. Guneshwar Sharma, Judge High Court of Manipur and Chairperson of the High Court Legal Services Committee, Honorable Mr. Justice Golmei Gaiphulshillu, Director, Manipur Judicial Academy, Shri Lenin Hijam, the Advocate General, Manipur, Shri S. Iboyama Singh, the Chairman, Bar Council of Manipur, Shri N. Kumarjit Singh, the President of the High Court Bar Association of Manipur, Shri C.S. Bimol Singh, the President, All Manipur Bar Association, dignitaries of the dais, top-ranking officials of the civil and military establishments, esteemed members of the bar and bench, registry officials, respected resource persons, distinguished invitees, members of the media fraternity, ladies and gentlemen, a very warm and good morning. It is with immense pride and profound respect that I, on behalf of the High Court of Manipur, the Manipur State Legal Services Authority, and the Manipur Judicial Academy, stand before all of you today to render a very warm and heartfelt welcome as we gather for this two-day state-level conference on some of the most crucial and evolving aspects of legal and criminal justice framework. At the very outset, I must express our extreme gratefulness to have the gracious presence of our Chief Justice, Honorable Mr. Justice K. Somashekar, and his companion judges, Honorable Mr. Justice A. Bimol Singh, and Honorable Mr. Justice A. Guneshwar Sharma, and Honorable Mr. Justice Golmei Gaiphulshillu, Director MJA, whose leadership and dedication to continuing innovative legal education have steered the entire judicial framework towards new vistas of interdisciplinary learning modules. This two-day event, carefully curated around the themes of NDPS Act, cyber law, and forensic evidence, and the much-debated 3 new criminal laws, is not merely an academic exercise. It is a timely, critical, and collaborative platform for cross-disciplinary reflection and learning. This gathering brings together a diverse and distinguished group of professionals and stakeholders numbering about 600 participants representing the judiciary, prosecution, police, armed forces, narcotic personnel, legal services, bar associations, students, and forensic institutions, all stakeholders who form the very foundation of our criminal justice system, and all united by a common goal to enhance our collective sublime understanding and efficacy in dealing with some of the most pressing legal challenges of our time. Today, as we delve into the complexities of the NDPS Act, cybercrime, forensic evidence, and the 3 new criminal laws, we are reminded of the dynamic and ever-evolving nature of the contours of legality. These topics are not just pertinent, they are critical to the administration of justice and the maintenance of rule of law in the society. The NDPS Act, with its stringent provisions and complex procedural requirements, poses unique challenges for law enforcement, the judiciary, and the legal practitioners alike. Our discussions will focus on the intricacies of search, seizure, arrest, and the custody of the seized articles, an area that demands precision and adherence to legal standards to ensure justice is served. I am confident that the deliberations shared by our esteemed speakers, including Dr. J.N. Baruwalia, the former Principal Secretary Law and District and Sessions Judge, and the practical insights shared by Madam Mona Lisa, former Special Judge, Nd&Ps Court, and her team will illuminate pathways to more effective implementation and adjudication. It is with immense gratitude and respect that I welcome you, sir and madam, as our esteemed resource persons to this conference. We also acknowledge the rapid technological advancements that continually serve the domain of cyber law. Cyber threats are becoming more sophisticated, and our legal responses must evolve accordingly. The expertise of Shri and John, SP Cybercrime, will guide us through this current cyber landscape, offering investigative techniques and a framework of cyber security that is both robust and adaptive. Our warmest welcome to you, sir. Further, in extending our warm welcome to Mr. Nato Loktongbam, Scientist, Central Forensic Science Services under the Home Ministry, we are sure that his deliberation promises to enhance our understanding of how technological evidence can effectively be integrated into the judicial process, ensuring the integrity and reliability of our legal outcomes. On the final day, we will confront the challenges posed by implementation of the 3 new criminal laws. Science, as we all know, is often met with resistance and difficulty, yet it is through reflection and dialogue that we can find a way forward. By addressing these challenges head-on, we aim to pave the way for smoother implementation at a ground level, ensuring that the laws fulfill their intended purpose. And I sincerely believe that the grounds shared by Shri Yumkham Rothar, District and Sessions Judge Imphal West, and his team will critically examine the issues on the field. Sir, we accord you and your team a very warm welcome to this August conference. Throughout this conference, we'll engage in reflective sessions that allow for audience insights, Q&A, and case analysis. This interactive approach is designed to foster a deeper understanding and to facilitate exchange of ideas and experiences that will enrich our collective knowledge. In conclusion, I extend my heartfelt gratitude to all the dignitaries, speakers, and participants for your kind presence and contributions. Thank you, and in welcoming you all again, I look forward to an engaging and fruitful conference. Thank you.
Thank you very much, Shri Ojes Mutum.
With kind permissions of the honorable dignitaries on the dais, Chief Justice of the Gaiphulshillu, Director, Manipur Judicial Academy, Shri Lenin Hijam, Advocate General of Manipur, Shri Sarangthem Brajabihari Singh, Chairman Bar Council of Manipur, Shri Naurem Kumarjit Singh, President. Today, as a President of All Manipur Bar Association and as a guest of honor at this vital state-level conference. The themes we gathered to explore, ranging from the NDPS Act to the evolving landscape of the cybercrime and the 3 new criminal laws, are not merely legal constructs. They are reflections of our society's shifting challenges and our collective responsibility to respond with clarity, compassion, and courage. The NDPS Act, while designed to curb the menace of drug trafficking must also be examined through the lens of justice and rehabilitation. As legal professionals, we must ask, are we protecting the vulnerable or inadvertently punishing the affected? The law must be shield for the innocent and the scalpel for reform, not a blunt instrument of the retribution. Cybercrime, too, demands our urgent attention. In a world increasingly shaped by digital interactions, the law must evolve to protect privacy, dignity, and trust. We must equip ourselves not only with the legal tools, but with the ethical foresight to navigate this complex terrain. As we use in 3 new laws, criminal laws, we are reminded that the changes is not merely procedural, it is philosophical. These laws will redefine how justice is delivered, and it is our duty to ensure that they uphold the principles of fairness, transparency, and human dignity. Let this conference be more than an exchange of knowledge. Let it be a call to action, a reaffirmation of our commitment to justice, to reform, and to the people we serve. Thank you, and I look forward to the rich discussions ahead.
Thank you very much, Shri Chakram Bimol Chandra Singh, President, All Manipur Bar Association. May I now invite Shri N. Kumarjit Singh, President, High Court Bar Association of Manipur.
A very good morning to you all. Honorable Mr. Justice K. Somashekar, the Chief Justice, High Court of Manipur. Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur. Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur. Honorable Mrs. Justice Golmei Gaiphulshillu, Director, Manipur Judicial Academy. Shri Lenin Hijam, Learned Advocate General Manipur. Shri S. Brajabihari Singh, Chairman Bar Council Manipur. Shri C.H. Bimol Chandra Singh, President, All Manipur Bar Association. Judicial officers, senior advocates, distinguished invitees, army personnel, officers of the government of Manipur, police officers, ladies and gentlemen. We are here today for the inaugural session of the 2-day state-level conference on NDPS Act, cybercrime, and 3 new criminal laws organized by the High Court of Manipur in collaboration with Manipur State Legal Service Authority, Manipur Judicial Academy at the City Convention Center in Imphal on this 23rd and 24th August 2025. We all know that the 3 new criminal laws, that is Bharatiya Naya Sahinta 2023, Bharatiya Nagarik Suraksha Sahinta BNSS, and Bharatiya Saksha Abhiniyam BSA have been enacted by the Parliament of India and enforced from 1st of July 2024. The introduction of these new criminal laws makes a significant shift in Indian criminal justice system, aiming to modernize and streamline the criminal justice system of the country, aligning with the current requirements and ideas. The new laws bring in positive changes, particularly from a procedural point of view, by introducing timelines and formalizing the use of technology in investigative and judicial process. Many provisions in these new laws are innovative and beneficial to the public at large. However, the effective implementation of the new criminal laws shall require an efficient and a flawless synergy between the bar and bench and the police. Conference like this shall foster such interaction and cooperation between all the stakeholders. With the evolution of society and the growth of human knowledge, there has been huge advancement of technology which has affected and impacted every facet of our daily life, but at the same time, this advancement of technology has also brought along new ways and means of committing crimes, leading to increase in cyber crimes and other related offenses. Further, all of us knows that the state of Manipur has been facing a severe issue of drug menace for quite some time, and our citizens, particularly our youth, are exposed to this menace. And we need to tackle this problem in order to shape the future of our state. In this two-day state-level conference, the members of the bar shall have the opportunity to interact with judicial officers, police officers, central security force personnel, bureaucrats, as well as subject experts to discuss on these issues and share their valuable experiences, insights, which will be extremely beneficial to all the stakeholders and more particularly the young advocates. I am very much delighted that the High Court of Manipur, in collaboration with the Manipur State Legal Service Authority and Manipur Judicial Academy, is organizing this two-day state-level conference, and I wish this conference a grand success. Thank you all. Jai Hind.
Thank you very much, Shri N. Kumarjit Singh, President, High Court Bar Association of Manipur. We now request Shri Sarangthim Brajabihari Singh, Chairman, Bar Council of Manipur, to address the gathering.
Good morning, everybody. Honorable Mr. Justice K. Somashekar, Chief Justice of High Court of Manipur, Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur, Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur, Honorable Mr. Justice Golmei Gaiphulshillu Kabui, Director, Manipur Judicial Academy, Shri Lenin Hijam, Learned Advocate General of Manipur, Shri Kumarjit Singh, President, High Court Bar Association Manipur, Shri Sakpram Bimol Chandra Singh, President, All Manipur Bar Association, respected dignitaries, invitees, and the media of today's function. I express my gratitude to give me an opportunity to deliver my opinion on this auspicious inaugural session of the 2 days state-level conference on NDPS Act, cybercrime, and the 3 new criminal laws. It is the right step of the Honorable High Court of Manipur, State Legal Services Authority, and the Manipur Judicial Service to organize such a most valuable conference. In my opinion, it will give an opportunity to impart, share knowledge, views, interests, and opinion amongst the legal fraternity. It will also give a privilege to take a concrete decision between the provisions of the Act or laws and the ground reality. Lastly, I suggest to organize such type of conference, seminars, and workshops at different districts of our state of Manipur. Thanking you all.
Thank you very much, Shri Sarangthem Brajabihari Singh, Chairman, Bar Council of Manipur. May I now invite Shri Lenin Singh Hijam, Advocate General, Government of Manipur, to share his address.
Honorable Mr. Justice K. Somashekar, Honorable Chief Justice of the High Court of Manipur, Honorable Mr. Justice A. Bimol Singh, Honorable Mr. Justice A. Guneshwar Sharma, Judges of the Honorable High Court, Honorable Mrs. Justice Golmei Gaiphulshillu, Director, Manipur Judicial Academy, Ms. Shri S. Brajabihari Singh, Chairman, Bar Council of Manipur, Shri N. Kumarjit Singh, President, High Court Bar Association of Manipur, Shri Chakram Bimol Chandra Singh, President, All Manipur Bar Association, our Registrar General, Ojas Mutum, learned senior advocates, other members of the bar, a resource person, and other delegates, officers of the state government as well as the central government, staff of the registry of the Honorable High Court, a very good morning to you all. It is indeed a privilege to be amongst you today in the inaugural session of the 2 days state level conference on NDPS Act, cybercrime and the 3 criminal laws. The NDPS Act is very relevant in the context of the Manipur, since drug offenses and the drug trade are posing a big problem in the state of Manipur in the recent times. It is only after the commitment of the state agency as well as the central agency that it was estimated recently that the drug worth over 500 crores were seized in the state by both the central agency as well as the state agency between 2017 to 25. This is actually alarming, especially in the small state like Manipur. Therefore, the relevancy of this particular 2 days program is, I think, in my opinion, that this is one of the relevant conference which will actually help the law enforcement agencies operating in the state of Manipur to properly prosecute as well as seize further drug menace in the state of Manipur. In fact, the burden to save the future generation of these countries lies in the shoulders of our state and central agency, because it is believed that this is the area from which drugs are being transported to the rest of the country through different routes. Cyber technology is starting to evade every aspect of human life and has become indispensable. On the other hand, cyber criminals are getting smarter day by day, and the number of offenders and the mode and method of crime are also evolving, thereby increasing the number of such cyber offenses and the variety. It is therefore very important that we discuss and deliberate and increase our awareness and expertise in cyber technology according to the evolving situation. We have been long governed by century-old laws, criminal laws in fact, that is the Indian Penal Code, the Indian Evidence Act and the Code of Criminal Procedure, which had become very old and anarchic, which was inherited from the time of British. The 3 new laws are made in adaptation of the changing need of the society, and also to tackle the new and varied mode of crime, but at the same time to carry out criminal jurisprudence with a human touch. On behalf of the government of Manipur, I am very much thankful to the Honorable Chief Justice of the High Court of Manipur for arranging such a 2 days state level conference on NDPS, cybercrime and 3 laws, criminal laws of the country. Thank you so much.
Thank you very much. Advocate General, Government of Manipur, Shri Lenin Singh Hijam, may I now have the privilege to request Honorable Mrs. Justice Golmei Gaiphulshillu, Director, Manipur Judicial Academy, to share her reflections.
Good morning. Mr. Justice K. Somashekar, Honorable Chief Justice, High Court of Manipur, Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur, Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur, Shri Hijam Lenin Singh, Advocate General of Manipur, Shri S. Brajabihari Singh, Chairman, Bar Council of Manipur, Shri N. Kumarjit Singh, President, High Court Bar Association of Manipur, Shri Chakpram Bimol Chandra Singh, President of Manipur Bar Association. Respected members of judiciary, esteemed officers from central forces, officials of the police, and officers, prosecutors, narcotic drug departments, distinguished legal scholars, members of the bar, representatives from civil societies, and all the dedicated participants gathered here, including the resource persons. It is both an honor and a privilege to stand before this august gathering at the commencement of the two-day state-level conference on cybercrime, NDPS, and the 3 new criminal laws. I extend my deepest respect and gratitude to each dignitary present. Your presence here is not just ceremonial, but a powerful testament to your commitment to justice, reform, and the rule of law. Today, we convene not merely to discuss statutes and procedures, but to engage in a dialogue that touches the very core of our society's evolving challenges. The digital realm has become a new battleground where anonymity emboldens malice and where the law must evolve faster than ever before to protect the vulnerable and uphold justice. Cybercrime is no longer a niche concern. It is a national imperative. From financial fraud to data breaches, from online harassment to deepfake manipulation, the threats are real, pervasive, and deeply personal. Our response must be equally robust. It must combine technological sophistication with legal clarity and ethical resolve. We must empower our law enforcement agencies with the tools, trainings, and legislative support they need to investigate and prosecute cyber offenses effectively, while also safeguarding civil liberties. The NDPS Act remains one of the most critical instruments in our fight against drug trafficking and substance abuse. Yet, it is also a domain that demands sensitivity. Behind every seizure is a story, sometimes of organized crime, sometimes of addiction, and sometimes of desperation. Our approach must be firm on traffickers, but compassionate towards victims. Rehabilitation, awareness, and community engagement must work hand in hand with enforcement. The introduction of Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Saksha Aviniyam marks a historic shift in India's criminal jurisprudence. These laws are not replacements. They are reimaginings. They seek to make justice more accessible, trials more efficient, and procedures more human. But laws, however well defined, can only be as effective if they are properly implemented. This conference is a vital step in ensuring that stakeholders, judges, police officers, armies, lawyers, and citizens understand the spirit and substance of these reforms. Let us remember the pursuit of justice, not the responsibility of one institution alone. It is a shared mission. It requires collaboration across departments, disciplines, and domains. It demands that we listen to each other, learn from each other, and lead together. As we embark on these 2 days of deliberation, may our discussions be rigorous, our disagreement respectful, and our resolutions forward-looking. Let this conference leave us not only more informed, but more inspired to uphold the law, not just in letter, but in spirit. In conclusion, as a director of Judicial Academy, I would like to appeal all the participants to fill out the feedback form, which is inside the bags, which is given to you in the registration decks. Giving your valuable opinions, suggestions, so that this academy going forward is able to keep the academy abreast of the every changing landscape of the laws and make a place for exchange of ideas and knowledge. Once again, I bow in respect to all the dignitaries present, whose wisdom and leadership continue to guide legal and enforcement framework. May this conference be a beacon of progress, and may our collective efforts pave the way for a safer, fairer, and more just society. Thank you so much.
Thank you very much, Honorable Mrs. Justice Golmei Gaiphulshillu, Director, Manipur Judicial Academy. May I now have the honor to request Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur, to address this august gathering.
Good morning, everybody. Honorable Justice K. Somashekar, Chief Justice of the High Court of Manipur, Honorable Justice A. Bimol, Judge, High Court of Manipur, and the Executive Chairman, Manipur State Legal Service Authority, Justice Golmei Gaiphulshillu, Director, Manipur Judicial Academy, Mr. Lenin Hijam, Learned Advocate General Manipur, Mr. Brajabihari, Chairperson, Bar Council of Manipur, Mr. N. Kumarjit, President, High Court Bar Association, Mr. C. Bimol Chandra, President, All Manipur Bar Association, learned senior members and the members of the bar, judicial officers, officers from the state, representative from the central and the state security agency, a member of the media and the invitees, and especially Dr. Burdo, who is the resource person coming from Simla for this purpose. Last time also we have one conference on the 3 new law that was confined among the prosecutor judges. That time lawyer was not there. The introduction, we want to trace out what are the challenges before us. But today we have all the stakeholders, investigator, prosecutor, judges, defense lawyer, and these 3 new law have certain new area which is not in the earlier 3 criminal law. Like now, under section 223 of the BNSS, first proviso provide a right to heard the accused before cognizance taken. But such provision is not provided under section 200 of the CRPC. First, the magistrate satisfied with the complaint. Upon examination of the complainant, summon process is issued to the accused here. The BNS first proviso of section 223 give a right of hearing to the accused before the cognizance. If the cause is frivolous, then court, the magistrate can dismiss at the threshold. But whereas under CRPC, even if no material without hearing, if no chance of hearing is given to the accused, summon will be issued, so it will be a protected procedure. So these are the new. So other day also I held one order, summon issue under section 223 first proviso, notice to the accused before pre-cognizance hearing was challenged before me. I said that it is not an aggrieved order. It is only compliance of the statute under first proviso to section 223 of the BNSS. So likewise, 0 FIR was the judicial pronouncement. Now it is included EFIR in the. So these are the area how FIR can be registered if one is not physically present at the jurisdiction police station. Then the ratio in Priyanka Srivastava about approaching magistrate when the police refused to register FIR now is incorporated, and then 174.3 subclause 3 of the BNS. Earlier it was already judicial order under section 156 subclause 3. So these are the new area where both the complainant, accused, police, judges have to conscious of the new development in this act. Then one more aspect about the nowadays most of the crime relate with the electronics, mobile. Most of the crimes involve mobile, at least mobile phone. So in the circumstance evidence, the role of CDR, call detail record, is very important to check whether the accused was within the area of the offense, within the perimeter of the offense, because the tower location will indicate that his active mobile number is there at the time of the offense. So there is a evidence that he was present. There can be a presumption that he was present at that time. But when I was session judge, I find that in most of the charge sheet, the CDR, copy of the CDR is issued by DG office, nodal officer which sits in the legal intercession unit, LIU. But when I went to National Judicial Academy, Bhopal, so in the training on we are taught that the certificate should be issued by nodal officer of the service provider. So in Manipur, what do? The police department wrote Airtel office at Guwahati, kindly give the CDR of this number for this period. They said, printout is taken and it is certified by the nodal officer in the DG office of legal intercession unit. So there is not admissible under the evidence 65B earlier. what it says that the certificate should be given by the nodal officer of the service provider. That means if it is mobile number is of Airtel, the service provider, the nodal officer notified by the Airtel have to issue the same certificate. Likewise, BSNL. So after that, I made them to file another fresh one issued by the nodal officer, not by the DG. DG maybe that is for the investigation purpose, it can be used. The material found in the DG, this one data can be used for the investigation, but for prosecution, for trial, the certificate under the Evidence Act, Early Evidence Act 65B, it should be issued by nodal officer. So after that training, I rectified that all the charge sheet. I said that you file another one. So some of the application, defense counsel objected, but I allowed because already it is that no new document. Original is filed for the duplicate. So I allowed most of the, nowadays all the CDR are issued by the, so these are the area we have to be aware, otherwise that CDR will not be meaningless. Then NDPS, I think, I will not speak much. Sir is there, he is the expert, but I want to say in Manipur that Manipur being a border state, most of the apprehension is at the hand of the central agency like Army, Assam Rifle, BSF, CRPF, CIS, mostly in the. So if any lacuna, any defect in the seizure, search, arrest is made by the non-police officer, that means central police agency, then it will affect the trial. The initial defect, it is very hard to be cured. So the reason for inviting all the central forces stationed in Manipur is only for that, not only the police, the central forces should also aware what are the precautions to be taken at the time of the seizure, arrest, search. So because so many Supreme Court judges that any defect in the search, if the person is not, personal search is made and he is not informed about his right to be searched before the Gazette officer or before magistrate, there is a ground for acquittal. So that is why we have invited not only the police, all the paramilitary and the central forces stationed in Manipur, we have invited them. And we have also invited in the consultation prior to this one when this is prepared. So I will not speak much on this one. Then I have one forest official from the forest department also there. But I see that in prosecution under the Forest Act, it is done very casual and routine manner. Forest product is seized. Accused, that is usually driver is produced before the court. He plead guilty. Same day, judgment is pronounced till the rising of the court and a 500 fine. But what happened to those product seized? Driver is only a mere agent. He may be knowing or not knowing. The kingpin is never prosecuted in Manipur. So I draw the attention of the forest department that in case of this measure, confiscation of timber or anything else, we should make a diet that the culprit should not escape. He should be the main accused, not the driver. Driver is very, even if he can be made an accused, his role is very minor. So I think we require a relook in the prosecution under the Forest Act. I will not take much time because technical sessions are there. So these are the few ideas I want to state that it is a consultative meeting because NDPS Act is a very stringent and the proof standard of proof is very high. There are so many presumptions against the accused, and likewise there are so many safeguards for in favor of the accused. So we have to be aware of this right of the prosecution, investigation, accused, even role of the judge. Thank you.
Thank you very much, Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur. May I now invite Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur, for his words of guidance.
My esteemed brothers, Justice K. Somashekar, the Honorable Chief Justice, High Court of Manipur, Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur, and the Chairman of the High Court Legal Service Committee, my sister, Mr. Justice Golmei Gaiphulshillu, Director, Manipur Judicial Academy, Shri Lenin Hijam, Learned Advocate General, Manipur, Shri Brajabihari Singh, Chairman, Bar Council, Manipur, Shri N. Kumarjit Singh, President, High Court Bar Association, Manipur, Shri C.H. Bimol Singh, President, All Manipur Bar Association, distinguished dignitaries of the dais, Shri Ojes Motum, Registrar General, High Court of Manipur, Member Secretary of Masalsa, Elek Muiva, and other high-ranking officials of the civil, army, and paramilitary forces, respected members of the bar and bench, learned senior advocates, young law students, friends from the media, ladies and gentlemen. It is indeed a pleasure and a privilege to be part of this important state-level conference. At the very outset, I must congratulate the organizers for choosing themes that are not only timely, but also deeply relevant to the administration of criminal justice today. A conference of this magnitude, bringing together nearly 600 participants from an array of multi-stakeholders, judges, advocates, police, prosecution, defense lawyers, forensic experts, narcotic personnel, law students, members of the armed and paramilitary forces, and media personnel, is a rare and welcome opportunity for introspection, dialogue, and capacity building. As I stand before you, I am reminded of something one of my senior mentors once said to me early in my legal career. Law is only as effective as the people who apply it. That statement resonates deeply with me today as we gather to engage with three of the most dynamic and evolving areas of our criminal justice system: the NDPS law, cybercrime and forensic, and the three new criminal laws that are reshaping the legal landscape of this country. The criminal justice system is often described as the bedrock of the rule of law. Yet, it is also one of the most dynamic areas of law, constantly adapting to new challenges, be it in the field of narcotics control, the explosion of cyber offenses, or the advent of entirely new codes of criminal law. The pace and complexity of these changes make forums such as this conference indispensable. They provide us with the shared space to examine the law not in the abstract, but in terms of how it actually works or fails to work on the ground. I am very much sure many of us have come across instances where an NDPS matter had to be dismissed solely because the search memo did not record the procedural compliance under Section 50. The evidence was there, the intent was clear, but the procedure was flawed. It only emphasizes how critical it is to train investigating officers and even the magistrates on strict procedural safeguards, especially in special laws like NDPS, where the consequences are severe. As for cybercrime, we are quite literally playing with catch-up with technology. Many of us in the judiciary, myself included, are still learning to decipher the anatomy of a digital offense. Is it hacking? Is it phishing? Or is it identity theft? We must acknowledge that cybercrime investigation today requires tools and training beyond traditional police methods, and that judges, lawyers, and all stakeholders too must adopt. I must stress that a particular focus of this conference is the 3 new criminal laws that have recently come into force. The 3 new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and Bharatiya Saksya Abhiniyam, represent a holistic shift. They aim to make criminal law more victim-oriented, time-bound, and technologically relevant. But I say this with sincerity: change is never easy, especially when the system is vast and diverse. While these statutes represent a bold attempt at modernization and simplification, we must also be candid in understanding and acknowledging the practical difficulties that are being faced in their implementation. I am also very sure many of our stakeholders must have genuine confusion and practical challenges while transitioning to the new criminal laws. Questions like, can the new FIR format be integrated with the existing systems? How do we ensure compliance with the new timelines for investigation and trial? Or question like, how do we adapt to mandatory videography in search and seizure or statements? These are not hypothetical questions. These are everyday challenges being faced in courtrooms and police stations across our state. We must also confront the ground realities that many stakeholder institutions still lack basic audio-visual infrastructures, that many investigation authorities might be unfamiliar with the terrain of new evidence documentation protocols, and many are yet to be trained in handling digital evidence as per the new Evidence Act. This is where conference like today's become crucial, not just for theoretical discussion, but for cross-learning. Let us hear from those districts and officers who have started adopting well. Let us document their best practices. Let us learn from mistakes without fear or blame. Because the success of this legal forum depends not on the text of the law, but on our ability to implement in the field. Further, there is a pressing need for continuous legal education and capacity building workshops. The statutes we enact are only as effective as the people who interpret and implement them. Conferences like this should not be seen as isolated events, but as part of an ongoing collective learning. Another vital point is the need for interagency collaboration. The presence today of senior officials from the police, the prosecution, the bar and bench, the armed and paramilitary forces, and civil administration reflects the truth that justice delivery can no longer be the responsibility of one arm alone. It demands a cooperative effort, and only through sustained dialogue and a shared understanding can we hope to meet the evolving challenges of crime. As we look ahead, I take opportunity to quote the word of the famous jurist, Justice Oliver W. Holmes. I quote, "The life of the law has not been logic. It has been experience. unquote. It is the practical experience, your experience as practitioners, investigators, officers, and juries that will make these laws workable and meaningful. I therefore urge all participants to engage fully, to share openly, and to learn generously over the next 2 days. The conversations here will be surely translated into better practices, stronger institutions, and ultimately a more robust justice system of our state. I wish this conference a grand success and trust that deliberations here will have a lasting contribution to the cause of justice. Thank you.
Thank you very much, Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur. It is now my proud privilege to invite the chief guest of today's inaugural session, Honorable Mr. Justice Kempaiah Somashekar, Chief Justice, High Court of Manipur, to kindly deliver his address.
Good morning to each one of you. On the dais, my dear brother Justice Bimol Singh, Judge High Court of Manipur, Executive Chairperson, Manipur State Legal Services Authority, my dear brother A. Guneshwar Sharma, Judge High Court of Manipur, and so also Chairman of the High Court Legal Services Committee, Sister Justice former Golmei, being a director, Manipur Judicial Academy, the learned Advocate General Hijam Lenin Singh, the esteemed Chairman Bar Council of Manipur, Singh sir, the President of the High Court Bar Association Manipur, N. Kumarjit Singh sir, the President All Manipur Bar Association, Bimol Chandra Singh sir. Of the dais, senior counsels, High Court of Manipur, and my dear judicial officers, registries, mainly Registrar General, High Court of Manipur, Mr. Hojes, distinguished gatherings, army personnel, lawyers, and the students of law, some investigating agency, the central agency, the state agency, and scientific agencies. The subject is very vast. The time is sometimes very constrainment. My brother judges have already been addressed the certain issues relating to the scope of the provision of law, inclusive of role of stakeholders in various capacity. And similarly, spell about the role relating to the particular agency. But my brother both spoke on relating to the certain areas of new criminal laws. That laws will come into force on 1st of July 2023. but the subject is very vast and not so easy to grasping and immediately. Criminal law will be set into motion only by receipt of a complaint. Neither may be oral complaint, nor it may be written complaint. But in the Criminal Procedure Code, it was come into force initially as an 1861, but the Indian Penal Code was come into force as on 1860. Both the Criminal Procedure Code and inclusive the Indian Penal Code, Lord Macaulay was the author. But after 1 year only, the Indian Criminal Procedure Code was come into force for effectively assist to the Indian Penal Code, what are the provisions are there. But the Indian Penal Code consisting in all section 1 to section 511, but now it is increasing in the Bharatiya Nagarika Samhita. But the Indian Evidence Act, it was come into force on 1872 as an author, Lord Stephenson, 1860, 1861, 1872. After lapse of several years, these three laws will come into force for effective implementation. But effective implementation of these three criminal laws, it is not so a day or even a month or even a year also to learning the intendment of the particular provision of law. It will take its own time, but it should be the learning process. As a judicial officer, as in any rank in the Indian judiciary, as a lawyer, from any rank, from the court of the JMFC to the court of the session judge, inclusive of the top courts. Every provision of law, it is not so easy to and easily understanding the ingredients of the said provision of law. But as I have already said that the criminal law was set into motion only receipt of a complaint, either in the written complaint or in a oral complaint. But section 2 clause D of the Criminal Procedure Code, it is defined what is complaint. The complaint defined, it is only the contents. It is his story. It is some complaint, that allegation made against the accused. The word using as an accused, till that period he is not an accused. Only it is an allegation. The allegation said to be proved, it is not so easy in the court of law. We have to follow the relevant provision of law only, because the doctrine of beyond reasonable doubt and benefit of doubt, these two doctrines are always to be embedded in our mind. As a judicial officer, in the rank of the JMFC, or in the rank of the CJM, or even in the rank of the district and session judge. But the trial is not so easy. The trial is always to be taken place by securing and summoning the witnesses. Summoning the witnesses may be, either may be witnesses cited in the charge sheet. The charge sheet said to have been filed by the investigating agency. But more importantly, soon after receipt of a complaint, the criminal law, it was set into motion only arrest. What do you mean arrest? There is no definition clearly in anywhere in the provision of what is a search in the criminal laws. Then arrest, search and seizure. Seizure is also the concept of seizure. There is no definite about some definitions relatability to these three areas. Arrest, it can be understood the judgment of D.K. Basu, there shall be some guidelines. What is arrest? Touching the body of a particular person to saying as you are under arrest, then only the wording, the meaning of arrest is completed. Once you must be informed you are under arrest. Unless you are under arrest to say that, just he is only a person who is accompanying with the arresting authorities. But you do not know that whether he is an arresting authority, whether having a power to arrest the accused, on what basis he has to arrest the accused. Once the person is under arrest by the arresting authority, entire rights, it has to be taken away from his custody. Because of the reason, the constitutional makers, even the draftsmen in the criminal law, they have to be given various provisions of law to protect the constitutional rights, then fundamental rights, statutory rights, natural rights, and human rights. But human rights was come into force as on 10th of December 1948 at midnight hours. But this country is also one of the signatory to that Human Rights Act. Because of the reasons, Human Rights Act, it is not so easy to understand by the judicial officers, by the investigating agency, by even for the Mahajar witnesses have been secured. But in these states, areas, I have noticed seizure memo. But in other parts of these countries, in various states, they may be using the word as a seizure Mahajar. The seizure Mahajar means seizing certain articles. It is in the presence of the punch witnesses, we call it as. Punch witnesses in the sense, he must be aware of that. He must be a localized person. Normally in the criminal procedure code has been stated. Then in his presence only the seizure Mahajar should to have been taken place. But it is a part and parcel of the charge sheet. But soon after seizure Mahajar, during the course of the seizure Mahajar, the investigating agency must be looked into what are the materials are very much required to be seized. For example, under the NDPS Act of 1985, some articles are said to be seized. What are the articles? Whether it is in the knowledge of the accused, whether it is in the knowledge of the felonies, whether it is in the knowledge of the gazetted officers, or any other officer has to be secured. That is the first and foremost of the relevant provision of that NDPS Act of 1985. Otherwise, the charge sheet it is only a formal charge sheet. What do you mean charge sheet? The charge sheet means sheet consisting some charges. Strictly speaking, charge sheet. The word charge sheet shall be understand the sheets consisting some charges relating to an offences which reflected in the FIR. The FIR said to have been recorded as under section 154 of CRPC. Now it is a different provision. It is corroborated. It is in the corresponding provision of the present BNSS Act. Therefore, the FIR means the first information report. Once the first information report has been recorded, there shall be some column. In that column, the copy of the FIR shall be furnished to the accused or felonies or even the offenders. Offenders, felonies and accused. But the different meaning has to be taken out in our mind as a judicial officers in any rank. Otherwise, his right is going to be violated. It must be in the conscious. It must be in the knowledge of the arresting authorities also, the investigating agencies also. In any rank, suppose NI Act, then NSA Act. What is 2008? What is 1980? Yes, 12 months period. 12 months maybe under the board is to be ordered. Yes, the board is maintained by whom? By the senior most judge in the High Court. But it has to be recommended by whom? It has to be approved by whom? That authority is a district magistrate. District magistrate is not an ordinary man. He is an IAS officer. Only the conferring power is a district magistrate. The magisterial power, it has to be exercised by him in accordance with law only, not whimsical and fanciful. In case whimsical and fanciful has to be exercising his power, then it is coming to force under the relevant provision of the Criminal Procedure Code, under the relevant provision of the Article 21 of the Constitution of India, to approach to the court of law as under Article 226 of the Constitution of India. But Article 226 of the Constitution of India, it is not so easy to be exercised, because the public peace and tranquility it shall be protected. It is the domain vested with the magisterial power. It is given to the district magistrate and inclusive the superintendent of police. Mere because some anonymous information has been secured, it is very easy. Securing the information anonymously by a person in the society, XYZ is intended to commit an offense. XYZ who is intended to commit some activities. Mere because that kind of an information secured by the investigating agency in any rank, either may be a police constable, either may be head constable, either may be a ASI, either may be a PI, equivalent to that CPI, or DYSP, or superintendent of police, or above that also. There must be understanding what is an information given by the third parties. Mere because given in information, whether we can be said that it is gospel truth. The truth is only to be established before the court of law by giving an opportunity to him. Otherwise, the doctrine of that, two doctrines are there in the criminal justice delivery system: beyond reasonable doubt, benefit of doubt. Therefore, the arresting authority must be understanding what is a power vested with him to arrest the accused. Arrest is very easy, but what about the rights of the family members? What about the rights of the family members? It should be think over twice, thrice, and several times. Suppose a caring woman, suppose a lacting mother, suppose sufferance with so many kinds of some infirmities in the mind, infirmities in the body, any purpose will be served. Because of the reason, certain provision of law, it is always to be that power is conferred to the judicial magistrate first clause. But section 190 of CRPC, ABC, now it is a corresponding provision in the amended act. What is A? What is B? What is C? What is section 200? What is section 202? What is section 204? Firstly, to be understand ourselves. Cognizance, it is not so easy. It is a mental equipment. It is a mental action. That therefore, the cognizance, it is a mental equipment, it is a mental action, it is based upon the materials facilitated by the arresting agency or investigating agency. That the judicial magistrate of the first class, even the second class magistrate being the revenue officers, as in the cadre of state civil services, they must be understanding what is remand. The executive magistrate, the tahsildar, or subdivisional magistrate in the cadre of assistant commissioner, in the first class executive magistrate, a deputy commissioner, or district collector, even though they have so much of power to remanding the accused, in case the accused has been produced before them, their power is only for 7 days remanding. But the judicial magistrate first class, his power is 14 days. Normally 15 days calculating either inflex or efflex. 1 day less, not less than 14 days. In case 1 more days remanding the accused, within a span of 60 days or within a span of 90 days, within a span of 180 days plus 90 days in the co-cause, sometimes it's an organization there. 1 day in case lapse. Suppose today is a 90 days. The investigating agency, mere because arresting the accused, mere because seizure of the materials, mere because production of the accused, 1 day in case it is lapse, then statutory power, it is come into force, it is a power vested with the concerned judicial magistrate or CJM or district concession judge. Then he should be released on bail. As under section 167, clause 2 of the Code of Criminal Procedure, it is a corresponding provision now in the BNSS Act. Because that is a compulsory bail, that is statutory bail, that is a defective bail. It should be granted even without expecting any something for executing the bond also. That kind of a power is required to be exercised by the judicial magistrate in any rank. But 193 of CRPC, it is a special provision for cognizance. It is to the special judges. In case SC/ST Act, in case any other special enactment, directly filing a charge sheet before the special judge, the special judge has to take a cognizance as under section 193 of the Code of Criminal Procedure. Now it is a corresponding provision is there. Because the dual capacity has to be exercised sometimes. Receiving the FIR, receiving the charge sheet, assigning the number, securing the accused, remanding the accused, and putting the case for trial. These are all the procedural aspects. But today's subject, it is very vast subject. It is very difficult to concentrating. Keeping in view the relevant difference of CRPC, keeping in view the relevant difference of the Indian Penal Code, and inclusive of the Bharatiya Nagarika Suraksha Samhita, but Bharatiya Nyaya Samhita, that is BNS, that is Indian Penal Code 1860. This act came into force on 1st of July 2023. But BNSS for short form, Bharatiya Nagarika Suraksha Samhita, replacing of the Code of Criminal Procedure, Bharatiya Sakshi Adhiniyama, that is BSE 2023, replacing the Indian Evidence Act 1872. But the laws aims to decolonize the Indian criminal laws, incorporate provisions relating to the organized crime, terrorism, mob lynching, sexual offences, and digital evidence, and make procedure more victim-centric and technology-driven. The challenges nowadays, there shall be some role. It is vested with the arresting authority, investigating authorities, investigating agency, medical agency, scientific agency. Yes, the police must be awareness about these provisions. The prosecutors, that agency must be aware. The judges, in any status, they must be also aware of these provisions. Then prison authorities, they must be also aware about these provisions. And the defense lawyers, yes, the role of a defense lawyer, he stood as good as a one of the immediate to the agency, to that accused as a guard. He must be taking such kind of a defense, otherwise, because of his inaction, because of his non-application of mind, the innocent accused will be receiving some conviction, receiving some gallows, mere because representing the accused no suffice, no purpose will be served. He must be stood like a rock. He must be defense like a rock. He must be defending the accused. He believing the defense counsel. He believing the advice of the defense counsel. You must dwelling in detail about the contents in the charge sheet. Then only he must be taking some defense. Otherwise, no meaning in it. These are all the important areas must be understood. The lack of uniform training may cause some inconsistent application of laws. The lower judiciary and the police stations in remote areas are especially vulnerable to the confusion during the transition phases. The same is also required to be considered and also to be taken into recourse in this conference. The BNSS makes forensic investigating mandatory in all offences punishable within a period of 7 years or more. The current forensic laboratories, for short form FSLS, are limited in number, unevenly distributed, and heavily burdened. The shortage of trained forensic experts and technicians leads to delays in evidence analysis. But evidence is concerned. Important provision is section 2 and section 3. Section 2 and section 3 and section 4, it must be read together, then only we can able to understand what is proved, what is not proved, what is disproved. What is may presume, what is shall presume, what is conclusive proof. But section 17 to 21, it is defined as admissions. But section 32, that's a dying declaration. But the role of a judge, it is too much in the Indian Evidence Act. But I have noticed, since very short period, there shall be some provision has to be make it use and also initiate the miscellaneous case proceedings. It would be causing for delay the proceedings sometimes. Must be change our mindset. change our brain. Changing in society. We are in the 21st century is approaching. We must be change our mindset. Because this brain is consisting what? So much of neurons. I can't say that. Every neurons, it is having its own dimension to think over it. There shall be some visions. But the judicial system in this country, there shall be some constraint because of this delay in process. The Indian judiciary already faces a backlog of over 4.5 crores of cases, even in the accountability of the civil cases or criminal cases. But huge pendencies are there. But fortunately, state of Manipur is very less pendency. Even though it is less pendency, but the human rights is going to be taken away by the certain agencies. It should not be happen. Leave them. Leave them to live happily. The human life is only for a span of either 50 years or 55 years or 60 years or 65 years. We are human beings. We must develop humanhood, human touch, human heart and human value. Unless these things, no meaning in it. Any differentiation between the human being and the being? I am doubting sometimes why that dictionary man using this word as a human being. I am defined as human plus being. In case having a human quality, you will be human. In case of being quality, you will be human plus being qualities. Then he will be the composite word as a human being. Section 45 of the Indian Evidence Act, it is made it clear. Experts' evidence. Who are the experts? Do you think everybody are experts? Yes, everybody are experts of their own knowledge. But any scientific officer has to analyze the material objects and give a report. It is only a opinion report. But the judge has to apply his mind. Read with section 73-74 of the Indian Evidence Act. Judge is an expert of the experts. Judge is always an expert of the experts. He should be having and also developing such kind of a knowledge in his mind. Not so easy to adorn the post as a judicial officers. He should be exercise the power without fear or favor, without any hesitation also. Because he is not an ordinary judicial officer. He is not ordinary, he is not a government servant. The government servant defined only for statutory benefits, salaries and perks. But the sovereign power, it is vested with the hands of the judges. They are the constitutional authorities. They should be think over it, what I am, where I am, how I am, how to discharge my duties. The duty it is discharging by the judicial officer as an agency of the God, as immediate to the God. Sometimes the innocent persons will be suffered because of the reasons. The cartoon case was rendered very long back. So many accused are languishing in jail. That they have been feeding by whom? That they have been managed by the taxpayers' amount. Therefore, section 436 is there, bailable offences. 437 is there, it is non-bailable offences. 438 is there, it is anticipatory bail. Then 439 bail is there, it is a regular bail, it is a conferring power. It is the district and session judge and the High Court judges. But Article 136 of the Constitution of India, it is extraordinary power vested with the top court in these countries. Like this, these are all the important provisions are very much required to be adhered. Must be having so much of knowledge to our mind. But it is very difficulty for us, very concentrating to all the issues in these matters. Sometimes the judges also very much required to be understanding the issues. The prosecutors also. The word prosecutor is not able to define it now. Even what is the prosecution? Don't think prosecution, it is only the definition of the prosecutors. The defense counsel stand, it is a definition as a prosecution. The complainant on side is stands, it is amount to prosecutions. like that intelligence is very much required to be adhere in our mind. But today's some NDPS Act 1985, it is very difficult to define it. Certain relevant provisions of law, it is also very much required to be adhere and also having so much of knowledge, especially section 42 and 43, that is a search and seizure. Section 50, search before magistrate or gazetted officers. Section 52 and 55, custody of seized items. And section 57, reporting obligation, there shall be some rule. That Information Technology Act 2000, along with the corresponding provision of Indian Penal Code 1860, the presently that Bharatiya Nagarika Suraksha Samhita, otherwise Bharatiya Sakshya Adhiniyama. I can't say that each and every wordings, but the three laws, it must be in a letter and spirit, and the ingredients of each one of the definition, we must be recital in our heart and soul. Otherwise, no meaning in it of Article 32 of the Constitution of India. This awareness, this conference only for capacity building of a police, prosecutors, and the judiciary. Awareness and training for law, enforcement in the new procedural code, that is 3 laws. Infrastructure gaps in forensic labs and digital system, transitional issues in ongoing cases under the old laws. These are all the things it is very much required to be acquiring more knowledge by the NDPS Act of 1985. And another concept is cyber law. Cyber law, it is a cybernetic world. Switch on and switch off. Switch on and switch off, it is arising some cause of action, arising some criminal activities. Whether we think that they are intelligent, everything it is to be invented by whom? By human beings. We should not become a slave to the machine. But our brain consisting so many neurons. Therefore, we must be apply our mind instead of technologically some instruments. Suppose 50, adding one cipher 500, another one cipher 5,000, so on and so forth. It is ascendancy. Yes, who is liable? Whether technical instrument is liable, whether this crime is committed by whom, these are all the things are very much concerned because of the reasons. Cyber laws, we are in the cybernetic world, we must be understand what is cyber laws. You know very well, State of Haryana versus Dinesh Kumar 2008, the Supreme Court held that the arrest means the act of being taken into custody under authority of law, with the purpose of answering a criminal charge or preventing a crime. Another 2 words I am adding, inculpatory and exculpatory. What is inculpatory, what is exculpatory? It is that kind of inculpatory and exculpatory can be understood only we are as a law student. The professor of law must be give some insight to the students of law. It should not become an industry. Industry, it is always to be production of the goods. But we are not a goods. We are a talking property. We are a talking property in the societies. But arrest by a private person, even though it has to be defined in section 43 of the old criminal procedure code. Even arrest by magistrate, as under section 44 of CRPC. Safeguarding during arrest, article 22 of the Constitution of India. Because of the reason that article 226, it has been make it use by seeking intervention of the detaining order as passed by the detaining authority as a district magistrate. Then section 41A, 43, 41B, 41D, section 50, 50A and 57, D.K. Basu versus State of West Bengal, 1987, given some insight to us, some guidelines to us. Preparation of arrest memo, informing relatives and friends, it is the mandatory. Medical examination of the arrested person under the relevant provision, right to consult a lawyer during investigation. These are all the important areas. The arresting authority must be having so much of knowledge. Otherwise, no meaning in it. There is no clear cut. Even search and warrant, section 93 to 98 of CRPC. We must be understand what is search warrant issued. We must be understand what is 165, 166 of CRPC, search without warrant also. Then search of a person as under section 51 and 100 of CRPC. Search and production before the court as under section 102, 165 CRPC. These are all the power it is vested with that. Not only to the investigating agency, it is a power vested with the judicial magistrate, the first class, and also the chief judicial magistrate. But the time is not in my hand. It is in the hands of the Almighties. But the distinguished persons are there. Some resourceful persons are there. They are the professor. There shall be some allocation of business to discussion and interaction. Therefore, in this conference, it is a unique conference. It will give so much of information to all the persons. And therefore, I am saluting to my brothers too, and including other dignitaries, because they are the mentors. They will be the making some endurance to this kind of conference. It is very much required to give some awareness to the investigating agency and also the stakeholders who are present in this podium box. I am standing before you in this podium stand, no problems. But in that area has to be sit and acquiring knowledge and receptive capacity, it is not in. Because body is present, but mind is absent. But we must be, body and mind should be present in that place itself. Till this day and also tomorrow's. Then only we can able to understand the purpose. It will be served. The service of purpose, it is only in the interest of the state of Manipur. My brother Guneshwar said that state of Manipur is very small state, something it is activities. Small is beautiful. Small is beautiful. Even in the UPS, Union Public Service Commission. Union Public Service Commission, sometimes State Public Service Commission. One question is to be framed sometimes very intelligent in case. Define small is beautiful. Small is beautiful, it is written by Dr. Somashekar. Unless reading that books, it is related to the economic concept. Never to answer to that what is defines small is beautiful. Because Manipur is very beautiful. Manipur is very small. But there is no issues. But there shall be some issues. But issues, I hope and trust, it is a human issues. Because human versus human. Human in one side, animals is another side. Because of the reasons elephants are enter into that our territories. The tiger is also sometimes enter into our territories. These are all the things are there. But at today's conference, it gives so much of information to the audience and also to the attendees. I hope and trust everybody must be carrying some information and delivering a lecture by our resourceful persons, not only to our judicial officer, to all the stakeholders, investigating agencies in any rank. Then only we can able to some more success. Our life is very short. Lastly, only 4 sentences I will tell. Charaka Samhita. It is very much important in these areas sometimes. Fortunately, free oxygen is available everywhere in the state of Manipur. But it is a God-gifted property. It's a God-gifted property because mountains, valleys and everything. But in Charaka Samhita, there shall be some giving, some information to us. We are human beings. Up to 44 years, it is a newborn child. Nothing is there to branding him. But after 45 years only, he will be watching some things. It is some domain vested with the parents. But our age is up to 40 years, no problems. Everything it is to be digested like anything, to eat any items. But after 40 years, the God will provide and also ex gratia. Like the university has given 5 marks added, 30 plus 5, 35 pass. Likewise, 40 to 50, 10 years, this is a grace period. Another 10 years also, maybe whatever the eating items to be taken, no problems. It will be taking care of this body. But after 50 years, then again the God will give and also showing mercy another 5 years. That is a grace period. After 55 years, every day there shall be some counting our days. Because of the reasons we are human beings, we must be adhere with human value, humanhood, human touch. Otherwise no purpose will be served. But this conference will give more insight to each one of you to carry the same, not only in your bag, it should be in your brain. God bless you all.
Thank you very much, our respected Chief Guest, Honorable Mr. Justice Kempaiah Somashekar, Chief Justice, High Court of Manipur, for sharing your profound knowledge and words of wisdom with us. Thank you very much, sir. As we bring the inaugural session to a close, I now invite Shri Alek Muiva, Manipur Judicial Service Member Secretary Masalsa, to propose the vote of thanks.
Good morning, esteemed dignitaries, distinguished guests, and all the participants. It is my honor and privilege to deliver the vote of thanks on the inaugural session of our 2 days conference on NDPS Act, cybercrime, and also the 3 new criminal laws. First and foremost, I, on behalf of the organizing committee, would like to extend my deepest gratitude to our esteemed chief guest, Mr. Justice K. Somashekar, Honorable the Chief Justice, High Court of Manipur, for gracing this occasion with his presence and for his inspiring inaugural speech. Lordship, your word have not only set a high tone for our deliberation, but also have provided us invaluable guidance. My sincere thanks goes to our esteemed guests of honor, the Honorable Judges of the High Court of Manipur, Director Manipur Judicial Academy, Learned Advocate General Manipur, Chairman Bar Council of Manipur, President High Court Bar Association Manipur, and the President All Manipur Bar Association. Your guidance and expertise will be the cornerstone of our discussion for over the next 2 days. I offer my profound appreciation to the distinguished dignitaries of the DICE, the Commissioner Homes, Manipur, Secretary Judicial, Manipur, and the DIGs of the various forces who are present here, and other head of departments. Your presence signifies the critical inter-departmental cooperation that is very much important for the effective implementation of this law. The conference would not be complete without the presence of legal community. I would like to extend a special and heartfelt thank you to all the senior advocates and advocates who have taken time out from their busy schedule. Your participation here is a clear indication that of your commitment to professional excellence and rule of law. I also extend a warm welcome and thanks to the professors from various law colleges and universities in Manipur. Your academic expertise and insight are crucial in preparing next generation of legal minds. To the students of law colleges and university, your presence here today is very significant. You are the future torchbearer of law and justice, and your eagerness to learn and engage in such conference is a source of great hope. My appreciation also goes to the officials from various departments whose work is directly impacted by this law. I thank the Department of Law, Prosecution, Forest, Forensic for the attendance. Additionally, I extend my gratitude to our partners in combating serious crimes, including officers from Police, Custom, Directorate of Revenue Intelligence, Narcotic Control Bureaus, Assam Rifles, CRPF, BSF, NIA, and CBI. Thank you for being here. The presence of panel advocates and legal aid defense counsels underscore our commitment to ensuring delivery of justice to all, especially to those most vulnerable and downtrodden sections of our society. I also profoundly thank to all the distinguished resource persons and panelists who will be sharing their invaluable knowledge, experience, and expertise over these 2 days. A special word of thanks to the media fraternity. Your role in disseminating information and creating public awareness is paramount. We appreciate your effort in covering this event and bringing this important discussion to the wider community. I would like to thank every single delegate and participants. Your presence is the very reason of our gathering here. We are excited what these 2 days will bring. My deepest gratitude goes to the judicial officers present today. My brothers and sisters, you are the pillar of our justice delivery system. Your presence and participation are vital, as you will be the ultimate person who will apply, adjudicate, and interpret the law in your orders and judgment. I thank you for your commitment to this immense responsibility and look forward for your active participation in the session ahead. A special thank to all the government departments that have set up stalls here below this conference hall. The stall provide valuable information and benefits for various welfare schemes, bringing this information directly to the participants. It is highly commendable. Finally, but importantly, I wish to extend a heartfelt thanks to all the organizing committee for their tireless effort in putting this significant event. Your meticulous planning and hard work have made this conference a reality. The inauguration today marks the beginning of 2-day session of learning, sharing, and collaboration. We look forward to a conference that is not only informative, but highly productive, laying a groundwork for a more robust and responsive criminal justice system. Thank you once again for your precious, gracious presence. Thank you.
With this, we conclude the inaugural session of this 2-day state-level conference. On behalf of the organizer, once again, I extend my gratitude to all dignitaries, learned members of the bar and bench, and participants for gracing this occasion. I now request all distinguished guests and participants to kindly join us for high tea arranged in your honor. May we respectfully request the honorable dignitaries and VIPs to kindly proceed towards the Northern Lounge area, and all other distinguished participants and invitees are requested to kindly proceed to dining hall number 1 and 2, where high tea is being served. Once again, thank you all for your gracious presence and participation. Pumna Magpu Kurumjeri. Yeah, Sikhi. Hello, hello. Mic off the wheel.
Now I request Joint Director, Manipur Judicial Academy, Maibam Manoj Kumar Singh, to kindly present Lengyan and token of appreciation to the next session's resource person, Mona Lisa Maibam, Register Vigilance, High Court of Manipur, and Bangalevi Joint Register, High Court of Manipur. Now, to steer us through the intellectual contours of this technical session, it is privilege to invite our esteemed moderator, Honorable Justice A. Guneshwar Sharma, to take charge of the proceeding. With his deep expertise and discerning perspective, we look forward to a session marked by insightful dialogue and scholarly engagement. Lordship Justice, the floor is yours.
Good afternoon. Since we are behind schedule, I will not take much time. As I mentioned in the morning session that, because now is the NDPS, I will confine to the NDPS only. NDPS is a stringent act which provide for normal offense minimum punishment 10 years, may extend to 20 life, and except for the personal consumption which provide for 6 to some 2 years, most of the offenses under NDPS are minimum sentence of 10 years. So with comparing to other normal criminal offenses, normally under the IPC, now under BNS and the other criminal offense, the standard of proof in a very stringent act, criminal act is very high. Here, there is no chance of error. Any error, any mistake, any lapses always goes in favor of the accused. So whereas in the normal criminal court, minor discrepancy, court used to discard that, give not much very clear. But in the NDPS, so in the NDPS there are 2-3 conflicting provisions, section 41, 42, 50, 52A. These are the right given to the accused, because these are the precautions, what search to be done, how seizures to be made. These are all provided. Any lapses in these inevitably lead to the acquittal. Whereas there are certain provisions like section 35, 54, presumptions of guilty mind and presumptions of a person is found with possession of a narcotic substance, then it is presumed that it is a conscious possession. So there is also an offense. Possession of a narcotic substance without license is an offense. So in order, this one is so this is a reverse burden. So in order to safeguard about the indiscriminate or implicating the innocent one, section 41, 42, 50, 52, 52A, these are a safeguard given to the accused also. If seizure is not done by as prescribed, a search is not done by prescribed, so these are the fatal in the prosecution. Then the role of FSL is also very important. Any conviction in NDPS case is not possible without a positive finding from the FSL. So the SARS and the finding of the FSL, I think should be consistent. But sometimes it may be due to overlapping, or we should take care that in one of the cases dealt by me, the the report is positive, heroin, and this, but what was sent and what was examined was different. A sample of round shape was sent, but what was examined was a triangular shape. The total color, the white color was sent, but some color. So what was sent and what was examined does not correspond, so that finding of the FSL, so if there is a positive finding, there is not, since is not, what was sent was not examined, so the conviction I have to set aside, I was constrained to set aside. So these are the few gray area. Every agency have their roles, and now we invited the Central Security Forces. As I mentioned in the morning, in Manipur, most of the seizure, search, seizure, fast apprehension is at the state of the Central Security Forces like Army, Assam Rifle, BSF, CRPF, CISF. So they should also know that these are the, at least how search, seizure, arrest should be made. That is sufficient for the Central Security Forces. But for the normal police who are doing the FIR, they should know other how sampling to be drawn and all those nitty-gritty of the cases. And one thing is that the provision of CRPC is also applicable in the NDPS case as far as consistent with the special provision of the Act. So arrest is not under the Act, NDPS, but we borrow from the CRPC now, BNNSS. So with these few words, I left the field to the expert, to Dr. Brajabihari, to take the charge.
Honorable Mr. Justice A. Guneshwar Sharma, Honorable Miss Justice A. Golmei, Gaiphulshillu, the Director of the Judicial Academy, Mayam Manoj Kumar Singh, Joint Director, Judicial Academy, Srimati Mona Lisa Mehboob, and Mangal A.V., the resource persons for the second session, and all my friends. I am grateful to the Honorable Chief Justice and judges of the Manipur High Court, the Director, Joint Director, and the Course Director of this conference for affording me this opportunity this afternoon to have interaction with you on a very important subject, which is NDPS Act, search, seizure, arrest, sampling of seized articles, safe custody, etc. Friends, you have heard in the morning thought-provoking speeches by Honorable Chief Justice and Honorable Judges of the High Court and other dignitaries. And I will only say that, not only say, but I must congratulate the Judicial Academy and the High Court of Manipur for conducting this seminar on very important subjects. All the three are very important subjects. I have my book on cyber law and cyber crimes also. So I know how much difficulty we are facing in cyber law today. So friends, I have served for more than 32 years as a judicial officer, and I have held the position of Registrar General of the High Court, District and Session Judge, then even Principal Secretary Law, all important posts. And from my experience, I can only say that hard work, sincerity, and patience, these are key to success. And law is nothing but common sense in a capsule. And there must be, as the Honorable Chief Justice in the morning has referred to Hossaina Khatun case, there must be speedy trial, because justice delayed is justice denied. So there are so many judgments of the Honorable Supreme Court that justice should be done at the earliest possible. Friends, I will only refresh the wording of the Honorable Chief Justice in the morning, that there should be humanity in all the agencies who are doing any service in the field of search, seizure, arrest, or deciding the cases. So on this point, I am remembered of the advice given by my Chief Justice at that time when I joined service. He was Mr. Justice R.S. Pathak, who later on became Chief Justice of India and then Judge International Court of Justice. He asked us, why you are joining this judicial service? So why we have joined service? Those who are in service, except advocates, senior advocates, all those, it is very important for them. We could not reply. We were 10 persons who called upon him. Then he told us that service is service to the nation, service to the society, and above all, service to the poor. Remember, service to the poor. And whatsoever you will get as a pay is not your remuneration. It is only a stipend with which you can lead a very good life. And your reputation will be your earning will be your reputation. Make such a reputation that when you are transferred from a station, people give the same respect to you, and when you retire from service, people give the same respect to you. So that is the advice which we have carried throughout our service career, and I think if we adopt this, then we can be very successful in our life. So friends, now coming to the subject, drugs. Every day we hear in newspapers, we hear in television and read in newspapers that huge quantity of narcotic drugs or psychotropic substances have been recovered from one or the other part of the country. And this menace is so grave that it has been the subject of international conventions like International Convention on Narcotic Drugs 1961, the Convention on Psychotropic Substances 1971, and Convention on Illicit Traffic in Narcotic Drugs and Psychotropic Substances in 1988, to which India is a party. So, drug abuse, drug addiction, drug trafficking, armed trafficking, money laundering, and narco-terrorism are some of the white-collar crimes faced by new millennium. And why this problem is there? First is drug war. Friends, I propounded this theory for the first time in Guwahati. It was a seminar organized by CASA for doctors of 7 states on NDPS. I was addressing that conference. I there propounded 2 things. First was drug war. That drug war is being fought by our enemy country on our land, with our men, with our material. Everything is ours. They only take our youth to their country, they train them, they give them drugs, put them on drugs, and then they supply them drugs and the guns. And they come back and they indulge in this drug war, in which these innocent persons are being killed. Second was that drug abuse and AIDS, they are interconnected. So nobody believed at that time, but thereafter, after about 1 year, I received a letter from Mr. Bora, who was director prisons at that time, IPS officer. He was director prisons either in Manipur or in Tripura, I don't know exactly. He wrote me that your this finding was correct. Both these things are correct as far as this area is concerned. So now, second is organized gangs of smugglers. So a kingpin who is sitting in his home, he can earn millions of dollars while sitting at home by one consignment from one place to the other place. Many governments have been overthrown by these drug lords, like the case of Cambodia. Then I will only give one small example. Sanji Mohan case, very important case, friends, I am citing it. Mr. Sanji Mohan was director of the Narcotic Control Bureau at Chandigarh, controlling 5 states. Nodal agency, NCB is nodal agency, and he was director of that nodal agency for 5 states of Himachal, Punjab, Chandigarh, Haryana, and J&K. So we had been giving lectures together in many NDPS workshops in Himachal and Punjab for 2 years. And then one fine morning, when he was director of Narcotic Control Bureau at Chandigarh, we read in the newspaper in the morning that he has been caught with a huge quantity of heroin in Bombay. So such a senior officer of the NCB himself was caught. So see what is the margin of profit, why he has done this. So this is the second reason, they want to create demand. And for this reason, there is drug addiction. The third is the activities of chemists and druggists. They sell fancy drill, Corex, diazepam, then proxybone, and though they can't sell without duplicate prescription, one, they have to keep with them, second, they have to give back to the patient, but still they are selling them without even prescriptions. So this is the third. Then we have this layer tourism has turned into drug tourism and jail culture. Even in jails, we hear so many news that from such and such jail, the drugs have been recovered from the accused. Then last is other reasons which are very small, that is peer cult, to have some, to solve some personal problem or family problems, there is parents' problem. So these are some of the, then coming to the main problem in Manipur, friends, in Manipur, Manipur has long been at the epicenter of the drug abuse crisis in northeastern region of India. The state's proximity to Golden Triangle, as Honorable Judge has told in the morning also, a region notorious for production and trafficking of illicit drugs, has contributed significantly to the proliferation of drug abuse in the region. So friends, the last available data for drug users in the state of Manipur is a study of 2019, which I could lay hand. It is 2019 study by the Union Ministry of Social Justice, which has recorded 34,344 injecting drug users in Manipur, more than any other state in the region. These are just injecting drug users. The overall number of deaths recorded in 2019 was over 1 lakh out of the population of 30 lakh at that time. 1 lakh, says Konsam Soja Devi, Deputy Director, Social Welfare Department. We estimate the number of drug users has only increased in the last 4 years. So this is the, now coming to what we are doing. We are catching hold of the drug peddlers or drug addicts generally. Where is the kingpin? So what happened? In 1996, I was invited by the Law Commission of India to draft the amendment to the NDPS Act. We discussed in that conference that kingpin should be arrested. And as a result, we proposed that controlled delivery system should be introduced in India also, as it was being in USA and other countries. So Section 50A was added in 2001 amendment. I don't know whether you have read Section 50A or not. It says that the director of the Narcotic Control Bureau or his authorized officer can allow the transit of any contraband in India from one station to another station, and even in the foreign country under supervision, to arrest the ultimate person for whom the consignment is meant. So the consignment can go even anywhere in India, 50A. You read Section 50A of the NDPS Act. Very important. You only allow only director or his authorized officer. They can allow this. You can move the director or any authorized officer. Okay, we have this information. I was just, yesterday we were discussing 500 crores opium, heroin smack was recovered. Madam Deputy Joint Registrar was telling yesterday when she was holding the charge of that district in the border. 500 crores. It is a big consignment which was recovered. So now coming to the Indian Parliament enacted this act in 1985, prescribing minimum punishment of 10 years with fine of rupees 1 lakh for most of the offences except 2-3 offences, Section 27 for small quantity for personal consumption. That was the only exception. Otherwise, it was minimum 10 years. And then in 2000, Amendment Act number 2 of 1989, breathtaking punishment of death penalty was also prescribed for repeat offences by the accused. So then in 2001, amendment was carried out in the Act whereby the seized articles have been categorized in 3 categories. First is small quantity, second is intermediate quantity, and third is commercial quantity. For commercial quantity, the punishment is very strict. Minimum punishment is 10 years and fine of 1 lakh, while for other small quantity, the punishment is only up to 3 years. So this is then the offences. I will come, sorry. Yes, first, now we'll start. Yes. This is Chittorgarh, where we have this cultivation of opium under supervision of Government of India. They have allowed the cultivation, and this is ripe for giving first cut for extracting the opium. The second, next. Yes. So drug war, all these I have discussed. Personal, family. Yes, next. Symptoms, next. Yes. Now sections, next. Important sections are Section 36, Section 37, Section 42, Section 43, Section 50, Section 51, Section 52, and Section 57. So friends, these are the important sections which we will discuss now. But before that, I will only say that judges have to decide, all my colleagues know it, that we have to decide the cases on the basis of, first is facts as brought out by the investigating agencies, maybe police, maybe Army, maybe BSF, maybe any other organization authorized under Section 41 of the Act. Then evidence as produced by the prosecution in the courts. Yes, next. Yes. As produced by the court. And third is law as declared by the Honorable Supreme Court of India, which is binding on each and every court under Article 141 of the Constitution of India, and the judgments of our own High Court and other High Court which have the persuasive value. So this is next. Yes. As we all know, investigation is not an end in itself, but means to find out the truth. When more stringent punishment has been provided, more strict provisions of law is there for investigation, and Chapter 5 of the Act prescribes special law, which is Section 41(2), I have already discussed. Now, friends, the investigating officers who are sitting here, investigation means what it means. It means to search first, search into, second, to examine closely, very important, and third, to explore. Generally, this third we forget. Investigating officers, friends, I must say that both judiciary and the police, they are the overburdened in this country. Any new law comes, the burden is always for investigation on the police and for trial on the judiciary. It is always there. But still we have to cope with this burden. We have to cope with this, and we have to. So, to explore, third is to explore. You have to explore why. Then friends, today there is scientific investigation. There is CCTV cameras everywhere, almost, everywhere. If you are catching some illicit or this narcotic drug from some person, if nearby there is some camera, CCTV camera, please use it. And if there is, he is in the CCTV camera with some contraband, naturally there is no question of acquittal. No question of acquittal. Second, you just when go on the spot, I actually don't have so much time, otherwise I have told you, you must go in the round, small circles you go on the spot, don't jump over the spot, and you can find some hair, some footprint, some handprint, and with those handprints by DNA, you can connect that accused with the recovery. And this is scientific evidence, conviction will be there. I must say that here in India, after 4 or 5 years in jail, we acquit the person that he is not guilty. Tell me, who is going to compensate that person for remaining in jail for 4 or 5 years? Nobody. His life is ruined. If on technical grounds he has been acquitted, okay, it's all right. But if there is nothing against him, then it is something we have to think over time and again. So investigation, aim of investigation is to bring out the truth, to locate the persons who committed the crime, to collect evidence, physical, oral, circumstantial against them, to arrest such persons and to bring them to courts. This is in Jamna versus State, AIR 1974, Supreme Court, the Supreme Court has held that the purpose of investigation is to bring out unvarnished truth, unvarnished truth. Next. Now coming to Section 36, friends, Section 36 of the Act lays down that offences punishable with imprisonment for a term of more than 3 years and offences punishable under Section 19, 24, 27A are triable by special courts constituted under the Act. So therefore, all other acts which are punishable with less than 3 years are triable by judicial magistrates. This is very clear because some years ago, there was a very confusion in many courts, many high courts and lower courts, that these 3 years, who is to decide these cases? So now it is clear that they are to be decided by judicial magistrates. Now section 42, very important section. It says that if the officer, being an officer superior rank in a peon, spy or constable of the departments of central excise, narcotics, customs, revenue intelligence, or any other department specially empowered by the Government of India, and likewise state government specially empowered, has reason to believe from personal knowledge or information given by any person and taken down in writing that there is some narcotic drug which can be recovered, he can enter into and search any building, conveyance or place. In case of resistance, break open any door and remove any obstacle to such entry, seize such drug and substance and detain and search, and if he thinks project, arrest any person whom he has reason to believe to have committed any offense punishable under the Act. But the proviso of this section 42 says, provided that if such officer has reason to believe that a search warrant or authorization can't be obtained without affording opportunity for concealment of evidence or facility for the escape of an offender, he may enter and search such building, conveyance or enclosed place at any time between sunset and sunrise after recording the reasons of his belief. So reasons of his belief, when it is to be recorded, when he has prior information or from his personal knowledge. If it is chance recovery, then it is not applicable. For example, the search is being conducted for traffic checking only, and during traffic checking, narcotic drug is recovered. Then this section 42 is not applicable. That is very clear. Now, compliance of section 42. It is a directory. Supreme Court of India has held it is a directory provision, not a mandatory provision. This is Karnail Singh versus State of Rajasthan. Next. No, back. Yes. Karnail, this is State of Punjab versus Balbir Singh, State of Punjab versus Baldev Singh. It is constitutional judgment. All these judgments are on this point that, and the last, I will refer to this, Karnail Singh versus State of Rajasthan, 2000, Supreme 414. It says, for application of section 42 of the NDPS Act, it is necessary that the officer empowered thereunder, before exercise of his right, has reason to believe from personal knowledge or information received regarding the movement of narcotic drugs. However, if the action is taken not upon his personal knowledge or information received, the requirement of section 42 of the Act would not be applicable. So where there is chance recovery, it is not applicable at all. Section 42 is gone. But now, as far as section 42(2) is concerned, recording of the and information and sending it to immediate superior officer, their judgment is State of Punjab versus Balbir Singh, then State of Punjab versus Baldev Singh, constitutional bench judgment. This second is constitutional bench judgment. Then Abdul Rashid Ibrahim Mansoori versus State of Gujarat, Karnail Singh versus State of Rajasthan. It says if there is total non-compliance of the provision, the same affects the prosecution case. To that extent, it is mandatory. But if there is delay, whether it was undue or whether the same has been explained or not, will be a question of fact in each case. So it is to be decided by our judicial officers by application of judicial mind whether the delay has been explained or not explained. And then Supreme Court of India, friends, Honorable Supreme Court of India itself in Karnail Singh versus State of Haryana 2009 judgment. Yes, this is, no, back. This is Karnail Singh versus State of Haryana 2009, 10 scale, 255. Very good judgment. They have said, while total non-compliance of requirement of subsection 1 and 2 of section 42 of the NDPS Act is impermissible, delayed compliance with satisfactory explanation about the delay will be acceptable compliance of section 42 of the Act. And they have given the illustration also in this judgment. Very important to illustrate if any delay may result in the accused escaping, or the goods or evidence being destroyed or moved, not recording and writing the information received before initiating action, or non-sending a copy of such information to the official superior forthwith may not be treated as violation of section 42 of the Act. However, where the police officer does not record the information at all and does not inform the official superior at all, then it will be clear violation of section 42 of the Act. And whether there is adequate or substantial compliance with section 42 of the Act or not is a question of fact to be decided in each case. So friends, it has to be decided by application of judicial mind by our judges, that whether there is explanation, there is reasonable explanation for delay or not. For example, the police officer or any other officer is on duty in the area. He is not in the police station. And he receives information there with the condition that if he is not arrested immediately, he will escape. So he can go, arrest him, seize the articles, and then on coming back to the police station or his unit, he can record this information. If he is from other agencies, then send it to the authorized officer under 53 or to the SHO as the case may be. So this provision is there. Then friends, in Sukhdev Singh, again the same. It is constitutional bench judgment, Sukhdev Singh versus State of Haryana, 2013 to SCC. It is constitutional bench judgment. In this also the same. Whether there is adequate substantial compliance is a question of fact in each case. So it is question. Then next question, very important question is, if the gazetted officer himself of the police or other department conducts search, what is the position? The Supreme Court of India in M. Prabhu Dayal versus Assistant Director, Directorate of Revenue Intelligence, 2003, yes, next. Yes, 2003, 8, SCC 449, where a search is conducted by a gazetted officer himself, acting under section 41 of the NDPS Act, it was not necessary to comply with the requirement of section 42 of the Act. For this reason also, in the facts of the case, it was not necessary to comply with the requirements of proviso to section 42 of the NDPS Act. Similar is the judgment in G. Srinivas Gaur versus State of AP, then State of Haryana versus Jarnail Singh, and so many other judgments. They have held that if gazetted officer conducts the search himself, then 42 is not applicable at all. Then he is not to record the information and then he is not to send it to the immediate superior officer before proceeding on the spot. So then coming to what is the effect of complainant, informant and investigating officer being the same officer? Any police officer, suppose ASI, he conducts search, arrests the accused, sends the Rukka to the police station to register the case, and then he investigates the case. What happens? From 2005, friends, when this act was, 1985, when this act was implemented, to 2016, the accused were being convicted. Even if the complainant and the investigating officer was the same person, not only by the trial magistrates or trial courts or only by high courts, but even by the Honorable Supreme Court of India. But in 2018, this judgment of Mohanlal versus State of Punjab came. Next. Yes. Mohanlal versus State of Punjab, AIR 2018, Supreme Court 3853. So this judgment came, it said, justice must not only be done, but must appear to have been done. Any possibility of bias or a predetermined conclusion has to be excluded. It is therefore required that a fair investigation, which is but the very foundation of fair trial, necessarily postulate that the informant and investigator must not be the same person. And in the instant case, as the complainant and the investigative officer is the same person, the appeal succeeds and is allowed. The prosecution held to be vitiated because of the infraction of the constitutional guarantee of a fair investigation. The appellant is directed to be set at liberty. So immediately he was set at liberty, accused, and in this way many accused were acquitted. Only on this point, Mohanlal judgment. Then I was delivering a lecture in Delhi Judicial Academy on 14th December, and on 30th December 2018, Indian Express carried a news that Punjab and Haryana High Court has granted bail to 28 accused on the basis of this judgment of Mohanlal versus State. And the question was put to me by the special judge, whether this will be applicable prospectively or retrospectively. I told that academically I can say it will operate prospectively, because there was a settled law earlier and accused were being convicted. So it has come a new law, it will be prospectively, but we have to wait for the decision of the Supreme Court of India. And friends, very immediately thereafter, Virender Singh versus State of Himachal Pradesh 2019 judgment came of the Supreme Court of India. They said this judgment of Mohanlal will be applicable prospectively, not retrospectively. Old cases will be decided as per the already settled law. Then the matter was finally referred to the Constitution bench, because there were conflicting judgments, Mohanlal and this Virender. Then matter was referred to the Constitution bench, and the Constitution bench in Mukesh Singh versus State 2019 judgment, 2020, 31st August 2020, this is this judgment 2020 10 SCC 120. SCC 120, in this Constitution bench judgment they have held merely because the informant is the investigator, by that itself the investigation would not suffer the vice of unfairness or bias, and therefore on the sole ground that informant is the investigator, the accused is not entitled to acquittal. The matter has to be decided on a case-to-case basis. A contrary decision of this court in the case of Mohanlal versus State of Punjab, and any other decision taken a contrary view that the informant can't be the investigator, and in such a case the accused is entitled to acquittal, are not good law, and they are accordingly overruled. The reference is answered accordingly. So in this judgment they have held investigating officer and the informant can be the same person. But the accused has to prove that prejudice has been caused to him on this account, only then he is entitled to acquittal, otherwise not. Then section 43, very important, it is public place. Public place is any garden, any school, any taxi, any bus, these are all public place. Any hospital, any other public place, road. So if it is in public place, then section 42 will not be applicable. Then you need not to record the information first, send it to the immediate superior officer. 42 will not be applicable at all, and the judgments are next. Yes. State of Punjab versus Baldev Singh. It is a constitutional judgment, right? In 1999, it was decided that 43, if the recovery is under section 43, then 42 is not applicable. Then friends, very important sections are there. 3 sections are very important, which we overlook. I think nobody has read those sections, neither investigating officers nor our judges. That is section 46 of the Act. It provides that it is the duty of landholder to give information of illegal cultivation. Very important section. I have come to know that here also in hilly tracts, opium is being cultivated without any license. So if it is being cultivated, it is the duty of the landowner to give information of illegal cultivation. That my land is there, somebody has cultivated there illegally something. If he has not given, then presumption will be that he has cultivated it and case can be against him. So this is important. Then section 47, friends, it says every officer of the government, very important, every officer of the government and every panch, sarpanch and other village officer shall give information of the illegal cultivation in his area. So for example, in forest area, cultivation is there, then range officer, DFO, any other officer. If government land, revenue officer, patwari, tahsildar, they are responsible to give information immediately that in this area, because every 6 months they have to go for Girdavari. In here also I think it is known as Girdavari or something else. After 6 months, they record what is cultivated in the land. This patwari does this work in our areas. So then this is also important. If they don't give the information, then there is a provision that they can be hauled up and they can be sentenced to imprisonment also. So this is important, which we have to comply with. Then section 48 empowers the magistrate of the first class or any other magistrate specially empowered to attach crop illegally cultivated. If illegally cultivated crop is there, then that can be attached. Now coming to section 49, it is very important section. It says that any investigating officer can stop and search conveyance of any conveyance if he has reason that there is any narcotic drug or psychotropic substance in that vehicle. For example, and what is the section, what it says, is about to be contravened or at any time stop such animal or conveyance, or in the case of aircraft compel it to land, even aircraft, and rummage and search the conveyance or part thereof, examine and search any goods on the animal or in the conveyance. If it becomes necessary to stop the animal or conveyance, he may use all lawful means for stopping it, and where such means fail, the animal or conveyance may be fired upon. So this power has been given to the investigating officer, so it can be. Now, next is section 50, very important section, friends. This is the only mandatory provision in the Act, only mandatory provision. If it is not complied with, accused has to be acquitted straight away, there is no other. So section 50 says that if any personal search, the word is personal search is to be conducted, accused has to be informed of his right to be searched in the presence of magistrate or the gazetted officer. So you have to give him inform him that he has a right to be searched before a magistrate or gazetted officer, and if he says, yes, I should be before gazetted officer or magistrate, he should be taken to the, otherwise you can conduct search yourself. So it is mandatory. State of yes, these are the judgments. State of Punjab versus Balbir Singh, this is 94 judgment, first judgment. Then constitutional judgment, State of Punjab versus Baldev Singh, 99 judgment. Then there are so many other judgments which say that it is mandatory and he has to be taken to the magistrate. Then even Yes. However, constituency in state of Punjab versus Baldev Singh, yes, this is there. State of Haryana, Gurvat Singh is state of Haryana. All these judgments are there. Gurvat Singh versus state of Haryana. Constitutional judgment, Vijay Singh Chandutya versus state of Gujarat, 2011 judgment. All these judgments are on the same point. If the accused gives the statement that he wants to be searched before a magistrate or gazetted officer and he is not taken before magistrate or gazetted officer, then he has to be acquitted. No compliance. It is the discretion of the investigating officer to take him to the nearest, the word is nearest gazetted officer or magistrate, whosoever is nearest. So you can take him to the gazetted officer, or he can't compel you that I should be taken only before the magistrate. Whosoever is the nearest, you should take him there and search him there. Then, if this right is not conveyed to him, he has to be acquitted. Nirmal Singh Palwan, judgment is there.
Excuse me, sir.
Jadeja, next. Nirmal Singh Palwan versus Inspector Customs, Punjab. So this is the judgment. If he is not informed of his right, he is to be acquitted. Then friends.
Sir, I have a question regarding this section 50, sir.
Yes, please.
Like we, in the chance recovery, sir, we don't need, chance recovery, sir, we don't need this section 41 compliance, sir. Yes. And like when we carried out like CASO and all.
We can take the questions, I think, later on. Let me finish first. We will take all the questions, I will take. Okay, I will take all the questions. Let me finish. Perhaps your doubt may be cleared. So friends, what is the personal search? First, I will tell you what is the personal search. If I am wearing this coat and it is to be searched, it is a personal search. But if I remove this coat, take it in my hand, it is not a personal search. If this is to be searched. Bag in my hand is not a personal search. Thali in my hand is not a personal search. But if I am wearing something, it is personal search. So this is the only difference which you have to keep in mind. Then, yes, no specific words are required. There is no pro forma for it. There is no pro forma how the right is to be informed to him. It is only general. You have to inform him. And in your statement in court, you have to say, and in your this challan also, you have to say that I informed him that you have right to be searched before a magistrate or gazetted officer. He gave this reply, and then you can proceed. So this is all. No specific words are required to be, and this is the case of Krishna Kamar. Yes. Krishna Kamar versus State of Rajasthan, 2004, Supreme Court. So in this judgment, they held that, as has been highlighted in the Baldev Singh case, Constitutional Bench, it has to be seen and gauged whether the requirements of Section 50 of the Act have been met. Section 50 in reality provides for additional safeguards which are not specifically provided by the statute. The stress is on the adoption of a reasonable, fair and just procedure. No specific words are required to be used to convey evident existence of the right. No specific words. Only thing is that it should convey that you have a right to be searched before a magistrate or a gazetted officer. That's all. That no specific words are there. So section 50 is only personal search, not the search of the bag. Next. These are all judgments that bag was searched. They said no. Bag is not personal search. Thali is not a personal search. Thali, one is Thali, one is this. Then Jarnail Singh case, State of Rajasthan, State of Punjab versus Baldev Singh, Tara Singh, all these cases, the recovery was from Thali or something else, or some bag or gunny bag. So they said it is not personal search. Now, section 50, clause 4 of the Act is very important. I am, I think, exceeding my time, but I will still take only 5 minutes, sir. 5 minutes, sir. 5 minutes. Next. Yes, 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 this is the case. Then back. Yes, yes, this is all right. This case, Section 50, Clause 4 of the Act, what it says, a lady must be searched by a lady. This is the provision under subsection 4. So, Supreme Court of India in state of Punjab versus Sundar Rani alias Shindi, 2002 judgment, they have held the provision of search of a lady by a female under section 50 clause 4 of the NDPS Act is mandatory, and in the case of non-compliance of the same, the conviction and sentence of the accused can't be sustained. So if a lady is searched by a male, that she will be acquitted by the court even if the recovery is proved. So we can't do anything. We are bound by the judgment of Supreme Court of India. Then non-compliance of section 50, accused can't be discharged, friends. Perhaps our special judges may discharge that this section 50 has not been complied with. Sometimes it is argued, and therefore why to carry on this trial? He should be discharged. This is a case of State of Himachal Pradesh versus Prithichan, AIS 1996, Supreme Court 977. It said, however, for non-compliance of mandatory provision of section 50 of the NDPS Act, the order of discharge of accused held to be improper by the Supreme Court of India. Even if search is found to be in violation of law, what weight should be given to the evidence collected is yet another question to be gone into during trial. Under these circumstances, it has been held by Honourable Supreme Court of India that the London Session Judge Mandi was not justified in discharging the accused after filing of the charge sheet, only holding that mandatory requirement of section 50 of the Act has not been complied with. So trial has to go, charge has to be framed, and then finally it has to be decided what is the effect of this section, non-compliance of section 50. Friends, then I will not discuss much, because when we were in the Law Commission of India discussing about amendments to this Act in 1996 to 1998, then I told that there had been a case when accused gave the option that I should be searched before a magistrate or a gazette officer, and Himachal is a very hilly state. He was being taken from that place to the magistrate, and the way he threw that contraband in the river, it could not be recovered. So how these are to be dealt with? Then this subsection 5 and 6 were proposed to be added, and finally in 2001 amendment these have been added. What this says, 5 and 6, when an officer, 50 clause 5, when an officer duly authorized under section 42 has reason to believe that it is not possible to take the person to be searched to the nearest gazette officer or magistrate without the possibility of the person to be searched parting with the possession of narcotic drug or psychotropic substance, he can search himself. And he has to record the reasons for such belief which necessitated such search, and he communicate the same to his immediate superior officer within 72 hours. So he can search, but within 72 hours he has to inform his superior officer why he has searched himself, what was the urgency, what was the possibility, and all these things. Then section 51 says that CRPC is applicable so far it is not inconsistent with the provisions of chapter 5 of the Act. As you know, this is there. Then 165 two independent witnesses have to be joined, but they can even be joined not from the locality, because the word is locality, of the locality. But there is one case, Durand Didier versus Chief Secretary, Union Territory of Goa. Yes, next. Durand Didier versus Chief Secretary, Union Territory, Goa, AIR, 1989, Supreme Court, 1966. In this case, what happened? It was a Kolba beach where this raid was to be conducted at the night time. The IO, he took the witnesses of the nearby of the police post because he was apprehending that no witness will be available at Kolba beach. Although it was a far off place, he took from there and searched in the Supreme Court also it was argued that witnesses are not from the same locality, respective persons of same locality, where they are from the neighborhood of the police post. Supreme Court said no. The explanation is there, so that they convicted this accused and sentenced him to 10 years imprisonment. So this is the case. Then there are 3 judgments, friends, which I can lay hand, that if independent witness is not there, on the basis of the judgments of the IO and the police officers or the other government servants, the conviction can be there. The accused can be convicted provided it inspires confidence. It inspires confidence. Friends, we all know, we all are sitting here. Accident take place in my presence, your presence, anybody's presence. How many of us will become the witness? Tell me. How many of us will take the injured to the hospital? Very few. Even honored judges of the Supreme Court in one of the cases remarked that even we will not, because police may harass us, that you are the person who had committed the accident. First of all, they will only implicate us. So these are some of the things. So these judgments say, and very good explanation was given. The IO said that I asked so many persons on the spot to become the witness, but everybody said no, I will not become witness. So I searched him in the presence of my constables. This is the recovery, and that person has been convicted by the Supreme Court of India also. This is to Smith Singh versus State of Punjab and Kulvinder Singh versus State of Punjab. 2 cases of the Supreme Court next. Both Smith Singh and Kulvinder Singh. These judgments, Gyan Chand, Smith Singh, Kulvinder Singh. These 3 cases, without any witness, independent witness, the accused has been convicted and sentenced to 10 years imprisonment by the Supreme Court of India. These are the 3 judgments, but confidence and how you present the case. If you say, okay, witnesses were there, they were joined, they go hostile, okay, it is something different. Then appreciation of evidence is there. But if you go and say, no witness was ready to join, and sometimes it happens, no person is come forward to assist you because there is no protection to him. He may be under threat from the smugglers. It's a very big lobby, friends. So 52 and 57 are not mandatory, they are directory, and any prejudice has been caused to the accused on such failure has to be proved by the accused, only then he will be acquitted. So this is State of Punjab versus Balbir Singh, Ashok Dhingra versus State of Madhya Pradesh. 2-3 judgments are there, so many other judgments are there. Now safe custody 55, section 55, safe custody and report of FSL, Zinder versus State of MP. It was that the articles were kept in the Malkhana intact, and Supreme Court of India held that accused has to be convicted because FS report is there and it was in the Malkhana intact. There was nothing wrong with it. Then safe custody of seized articles and samples has been established by cogent evidence. Forensic science laboratory shows that the samples were received in sealed condition with seals and tags. In fact, that being so, there is no infraction as alleged. Krishna Kamar versus State of Rajasthan case. So this is next Krishna Kamar versus State of. When there is doubt, another doubt about the sample on the basis of contradiction as to color. Sometimes one witness says the color was such, forensic science laboratory says the color was different. The Supreme Court of India held that when sample was found in sealed container intact, fit for testing, it has been held that it can't be doubted that material seized and examined was different, so it was accused, was convicted. This is Jagdish Budhraj, because they said color changes with the passage of time, especially if you have seen this opium, it changes its color. This church, it changes its color with the passage of time. Then another judgment is variation in payment. For example, you take sample of 5 grams. in the laboratory it is less than 5 grams. So Supreme Court of India has said minor discrepancy in the weighment will not affect the case of prosecution. It is Rajesh Jagdamba. Next. Rajesh Jagdamba, Swasti versus State of Goa. They said if there is a very minimal and almost ignorable change in weighment, because they have computerized scales there. We have that old scale. So that is the problem. Then reduction, another is Madan Lal versus State of Himachal Pradesh, same accused were convicted because there was minimal. Then whether content of whole of the article is to be for commercial quantity, whole of the article seized or only the content of the narcotic drug is to be taken. This is E. Michael Raj case, very important case was there. It was in 2008, it was held that the content of the narcotic drug is to be seen. For example, 740 grams of heroin was recovered. The percentage of heroin was 16.93%. So 120, they said 125 grams heroin is there. It is intermediary quantity and not commercial quantity. But friends, thereafter, one notification of 18th November 2011 came of the Government of India. They said the entire quantity is to be taken into consideration for the purpose of small or commercial quantity. So this is. Then the matter was referred to the larger bench, and the larger bench in Hira Singh versus Union of India has held on 23rd April 2020 that this judgment is not a good law. They have held that E. Michael Raj case is not a good law in case of seizure of mixture of narcotic drugs or substances with one or more substances. The quantity of neutral substances is not to be excluded, and entire catch is to be taken for the purpose of commercial quantity. This notification was upheld, and they said according to the notification, entire quantity is to be taken for the purpose of. So friends, last but not the least, drug traffickers can be termed as merchants of death and destruction. A murderer can kill 1 or 2 persons, but drug traffickers spoils the life of lakhs of people at the same time. So we can't pardon him. We have to be very strict with them, but with the paucity of time, we have to live with this constraint of time. And with this, friend, I stop my lecture, but we will have interaction, I think, after lunch. So please have your sumptuous lunch, because that is necessary for keeping our body fit. So after this lunch, we will discuss your questions and answers we will take after lunch. Thank you.
Thank you, Dr. Zain Baruwalia, for illustrated expression of the all NDPS Act. After lunch, we'll have a question answer session with Doctor. And since we are behind time, we have truncated lunch. We'll assemble here at 2:15.
Okay.
Raise some question.
Monalisa Maibam, former NDPS Manipur and currently serving Register Vigilance High Court of Manipur, and respected Mem Sarungba Mangalevi Devi, Joint Register, Judicial High Court of Manipur, to take on the stage for an insightful discussion for our second session along with the first session. To continue the Q&A session for the first technical sessions, I request among the participants, do you have any questions? So if you have, so please directly ask the questions to our resource persons.
Good afternoon, sir. Sir, this is Additional SP Imphal East. My name is Shankar, and I wanted to know, sir, regarding this, what do we call actually as chance recovery? Chance recovery regarding NDPS.
Okay, friends, there is a very good query or a question. What about the chance recovery? I have already discussed this point that in chance recovery, neither section 42 is applicable nor any other section is applicable, but after the recovery, the procedure of NDPS Act is to be complied with after the recovery. Because recovery is prior to you come to know that it is a case of NDPS. For example, there is a theft, and in theft you have laid down the naka and you are apprehending the persons, and in that naka, that search, you got some narcotic drug from a person. Then it is a chance recovery, but thereafter the procedure of NDPS Act will apply after their recovery. After the recovery, you have to inform the police station and record the information. Then you can send it to the immediate superior officer. Thereafter, that is the procedure which you have to follow. But in chance recovery, section 42 is not applicable. Not 50 is applicable because it was not prior information regarding narcotic drugs. There is a judgment of Supreme Court on this point, so many judgments, Baldev Singh, then this Balbir Singh, 94 judgment, 99 judgment, they are there. I have circulated, I think, the material to you.
Good evening, sir.
Yes.
So my name is Sandeep Kumar Neeraj, and I am second in command in CRPF. While explaining section 43, I guess, you said bus, taxi, but there was no mention of private vehicles like car, scooter, motorcycles, etc. etc.
Well, car, scooter, they are not public transport. They are personal transport and they are private, not public.
Sir, my question is,
yes,
will the search of private vehicles will fall under personal search or otherwise, sir?
It will be not personal search. Vehicle is search of the bag, house. Likewise, it is a search of the house in a way, or enclosed place. Enclosed place. You say enclosed place, it is search, it is not personal search. So section 50 is not applicable there unless the search of the person is conducted thereafter.
His bodily search is, when his bodily search is conducted, then it's personal search only, sir.
Yes, body, only body, not car. Car search is, it is search of enclosed place, like a house, any other place, search is there.
Thank you, sir.
Any other question?
Yes, sir. Yes, sir. I have a question here.
Yes.
I'm Bilashini from Forensic Scientific Officer. So is there any compulsion for testing the drugs on the spot when the drug is seized under NDPS Act?
Please repeat the question.
Is there any compulsion for testing the drugs on spot, the preliminary test, while the drug is seized?
Yes.
Under
When
NDPS Act?
there must be kit, testing kit with the IO, and he must test it on the spot if there is prior information. But if it is a chance recovery, naturally he will not have the kit with him, so there is no question of this is testing on the spot.
So the IO can test it on the spot. There is no requirement for the forensic expert team there, I think then.
There is no requirement of?
Forensic expert on the spot while seizing the
No,
drugs?
not forensic science. That he will sit in his office, there he will give the report. Only from the testing
Actually,
kit.
we are often called on the spot for testing on for the preliminary test.
Yes.
So,
Preliminary test.
the mobile forensic team visit the place of the seizure, and we are doing the preliminary test on the spot. So I think there is no compulsion for expert team to visit the scene, I think so.
There is no compulsion, but if he goes there, if suppose the consignment is a very large consignment on the spot, then sometimes he can be called, forensic science expert can be called. Like murder case, even in murder cases, they are called on the spot. So if he is called on the spot, he can take preliminary preliminary report he can give there, but final report he has to give in the laboratory itself.
But the thing is, the IO himself can test the drugs if he has the kit.
Yes, he has the kit. From kit he can test it. That he has to do it.
Okay, thank you.
That is
sir.
compulsory.
Okay,
that is compulsory. Any other question, please? Because I will learn from your questions. This learning process goes on till the last day.
Yes,
So
please.
I have to learn, you have to learn from each other's experience. Yes, please.
Excuse me, sir. My name is Hijam from Visal Law College. Would a search of a female by a male officer amount to a violation of Article 21, right to dignity? If yes, should it trigger compensation and criminal liability against the officer beyond Section 58 NDPS?
Search of a female?
Yes, sir. Search of a female by a male officer.
Yes, as far as search of a female by a male is concerned, it is not permissible. The female will be acquitted under Section 50 for non-compliance of Section 50, Clause 4 of the NDPS Act. As far as human rights violation is concerned, that is not to be seen at the time of trial of the NDPS Act case. The complaint can be filed by the aggrieved person with the police or with the appropriate authority on which the action can be taken. But in NDPS Act case, there will be no provision, there is no provision for compensation or any other thing to the complainant. To that lady who has been searched by a male. There is no provision in NDPS Act. But human rights, he has to go. That is academic question, and somebody can go and lodge the report that this has happened.
Sir, one question, sir.
Yes, sir.
I am Inspector Ibomcha, NAB Manipur, sir. Regarding section 50 clause 4 NDPS, the search and seizure procedure of a woman be done by a female person, and also amended that there should be done before a magistrate or gazetted officer. As per new law, videography is mandatory during search and seizure under section 185B NSS. In this regard, sir, the question of dignity arises, whether we drop the videography or continue the search and seizure, sir.
No, if she is being searched by a lady, videography can be done, no problem in it. Because she is being searched by a lady with decency. With decency. The question is, it should be with decency. Search should be with decency. And I may give you one example, very good example I will give. What happened? There was a raiding party. There was no lady in the raiding party. No lady constable was there. No lady ASI was there. It was all male party. Then the IO, what he did, he called a local lady from the village, asked her to search that lady, not in his presence, but otherwise, with decency. That lady searched and contraband was found. The lady, that case went up to the Supreme Court and conviction has been upheld because she was searched by a lady. It is nowhere written that she should be searched by a lady police officer or lady investigating officer. The word is she should be searched by a lady. So even a witness, if you have no lady with you in the raiding party, you can call some witness, lady witness, respectable person, ask her, okay, take her in some private place, search her, and then you can rather accordingly, on the basis of search, you can prepare your search memo and case can be presented in court. This is a very good example of search of a lady by a lady. The word is search by lady by a lady. That's the only requirement. Any other question, please?
One request to all the participants, when you ask any question, so kindly raise your hand so that we can recognize you well. So even the camera cannot focus you. So kindly.
Sir, may I add my view on some of the questions from the participant? Yes. This way. Sir, we just received one query regarding chance recovery. I want to give my view. If you go through section 41, 42, the word used is reason to believe. So, if there is no reason to believe, it will be chance recovery. Chance recovery, in short, means accidental discovery. So there is a difference between chance, reason to believe, and reason to suspect, according to some judgment. So if it is a case of reason to suspect only, section 41 will not be attracted. For example, if you go through it, reason to believe means reason, information received from personal information or from some other source. But you don't, let's take the hypothetical situation. You saw some suspected people. You don't have concrete information, but you have some suspicion. In such cases, section 41, requirement section 41 will not be attracted. That is some observation made in some of the judgment. And another question mentioned by one of the participants is regarding public vehicle. In one judgment, even private vehicle, if it is used for public purposes, it will be deemed to be a public vehicle. It doesn't mean that public vehicle doesn't mean that it should be belong to the government. Even private vehicle can be public vehicle, depending upon the purpose. Just my view.
Well, as far as private vehicle is concerned, if I own a car and I am in the car and it is being driven by me, naturally it is my private car, it is a private enclosure of mine, no third person can come inside, so I am responsible for it. So it is not a public place. We can't say it is a public place. Yes, taxi, bus, transport, which are public, transport, public bus, public, anything public for the use of the public. Private car is not for public. If there is some judgment, I will be very grateful to you. You supply me that judgment that where it has been held that a private car can also be a public place.
Sir, I was NDPS just till the year 2020. Afterward, I was transferred.
Okay.
So that was the position of law. I don't know the latest, but that was the commentary I came across.
Okay.
Even public vehicle, if it is used for private vehicle, if it is used for public purpose, it will be deemed to be public motor vehicle.
No, it can't be used. How it can be used? Because it is violation. It is a violation of the very law of the country. A private vehicle can't be put to public use. You can't carry passengers in a private vehicle. That is illegal. Illegal which is being done. So there the liability of owner is very much there. In taxi, in this public vehicle, the responsibility of the owner is very less. He is not responsible if anything is found in the public vehicle. But if in private vehicle anything is found, contraband, then owner is liable. Owner is liable. That's the difference which we must understand frankly, because it can't be put to public use. Yes. Any other question, please?
Sir.
So we can continue next session, I think.
So I would like to ask a question.
Yes, yes, please.
So as per the section 47 of the NDPS Act, it states that every officer of the village level and district level, they should inform illegal cultivations of any other drug substances in the premises, similar to as a fundamental duty of a citizen. The question is, how courts ensures that witnesses are protected and their testimony is effectively recorded? How far human rights are...
Sir, sorry to interrupt you, so we cannot hear you clearly about what you just asked.
Please, speaker.
Let me try again, sir. As per the section 47 of the NDPS Act, it states that an officer at the village and district level should inform illegal cultivations to the authority, similar to as a fundamental duty as a citizen. The question I would like to ask is that, how can courts ensure that witnesses are protected and their testimony is effectively recorded? How far human rights has been concerned? In accordance to this section, as a human, everyone is fair to death and they have the right to live happily in their family. Is my voice not clear, sir?
Yes. Friends, I may say one thing,
Yes, sir.
that court can't protect the witnesses, but there is a Witness Protection Act now coming into force very shortly. Thereafter, the witnesses will be protected by the government, because how court can protect? We have no force in court. So the thing is that government has to come forward, and they are coming forward with this Witness Protection Act. They are coming forward, and the day it is enacted, naturally the protection to witnesses will be there. Now, as far as the reporting of this illegal cultivation is concerned under section 47, this is regarding revenue. Suppose there is a government land, then the Sildar, Patwari, or those officers who are concerned with it, they have to report. Sport is a panchayat land. Then panchayat, sarpanch, panch, they have reported. If it is a municipal area, the commissioner, the mayor, the members of the municipal committee, they are to report it. If it is a forest land, the forest officers are to report it, because it is their land. If in their land illegal cultivation is there, they have to report. Secondly, the illegal cultivation, if it is on government land or in forest land, it has to be destroyed. But friends, I am sorry to say, in every conference, I say that this destruction should be done at the very initial stage. When the plants are very small, you destroy them. But what happens? The destruction takes place when half of the crop is gone in the market. And the next year's seed is also there in the government land or private land. So it should be destroyed at the time when the plants are very small, if we want to eradicate this problem. And friends, I must say, 2 states, Kerala and Tamil Nadu, they have done excellent work in this field. They have destroyed the entire illegal cultivation through helicopters, spray from the helicopters. They have done very, very nice work they have done. So we can also do it.
Excuse me, sir.
Yes.
I have a question. So earlier we talked about the dignity of women regarding the search of the female. So my question is, it is said that the female search should be done by a female officer or in front of a female. So regarding the videography of the female search, can it be assessed by a male officer after the search is done? And if so, if the male officer can assess the videography, then what is the point of not letting the search be done in front of a male officer?
Well, male can't take videography when search is being conducted. After the search, he can take the videography after the search of the articles recovered and her presence on the spot. They can be proved by videography. But as far as the search is being concerned, during search, he can't do the videography because he's a male. So the only question is decency of lady has to maintain. That is the only point which every court has to see. Even the Supreme Court will see, every court has to see.
Sir, I was asking that can the male assess the video after the videography is done? I didn't mean if the male can take the video.
Well, that is a question which I think how a third person can see it. Yes. As far as the investigating officer is concerned, he has to see it before presenting the challan, whether it has been recovered from her or not. He has to be satisfied. So he has to see, then court has to see. That is official duty which you are doing. But you are not affecting the human rights of any lady at that time when you are seeing videography after the incident has occurred. So it can be seen afterwards. Only by the authorized officers, not general public.
Excuse me, sir.
Yes.
I have a question.
Yes, please.
My name is Singh. I'm a law student. Whether the arrest and overnight detention of a civilian from his residence without a warrant and merely on suspicion or wrong information of having caused a physical commotion against the police is lawful? And if not, what legal remedies and actions can be initiated against the arresting officer?
Well, it is for the person who is arrested. He can go in for a case against that person for giving wrong information to the police. And in that case, he can get the compensation or any, that is for him. Under IPC and CRPC, he can lodge the complaint with the police. That is for him, not for the police officer during investigation. 180, 192 or some section is there, old section. Yes. While cancellation challan is presented, then at that time, 182, it was an old case, old CRPC 182 case can be against the person who has given wrong information.
Thank you.
Any
Sir,
other
I have
question?
one question, sir. I'm Hijam, sir. OC NAB, sir. According to section 176 clause 3 of BNSS 2023, mandates that a forensic expert must visit the crime scene and videograph by 7 years or more imprisonment. Unlike other criminal laws, cases are registered after seizure and arrest. For NDPS cases, there will be no value for visiting the crime scene after registration of the case. So we generally call FSL to assist the team while the search and seizure procedure is done, sir. So what is your opinion regarding this, sir?
Can you repeat the question, please? I could not understand.
Sir, in other cases, case register, visiting of the forensic science was done after the registration of the case. For NDPS cases, search and seizure is done before registration of the case, sir. So, according to the 1763 of BNSS, mandates that a forensic expert must visit the crime scene of the offense, for the offense, more than 7 years and imprisonment. So, visit of forensic expert is must in NDPS cases, sir.
Which is section 4? In 7 years.
And there will be no value for
well, special procedure has been prescribed under the NDPS Act, Chapter 5. And 151 says, so far it is not inconsistent with the provisions of this Act. CRPC is applicable. So, new Act will also be applicable, which is not inconsistent with that. So, in that it is written that sample will be taken. The procedure is given in the NDPS Act, Chapter 5. Sample will be taken. It will be sent to the forensic science laboratory. Report will come from there. So there is no question of expert visiting the spot under the NDPS Act cases. It is a very clear provision under Chapter 5. So when this is clear provision is there, then it is inconsistent with this provision of new Act is inconsistent with this provision. So that will not be applicable in NDPS Act cases. Yes. Any other question?
It means that, sir, it is not mandated in the NDPS cases visiting FSL in the crime scene, sir.
Is it mandatory for FSL to be present at the crime scene?
No. No, there is no such provision in the NDPS Act. There is no such provision.
So, sir, we will not follow the BNSS in these NDPS cases, right, sir?
Well, we are bound by the law. We are bound by the law. Even if I know that this person has committed murder, I know personally. But when I am sitting as a judge, I can't decide that case that he has committed the murder unless evidence comes before me, because I have to decide the case on the basis of evidence and the facts and the law. Three things. So if law is there, then I can't go against the NDPS Act, provisions of NDPS Act, to apply those provisions of the new Act. I can't, because it is clear not inconsistent with the provisions of the NDPS Act, Section 51, very clear. So it is inconsistent with the, because it is provided that sample will be taken in the presence of magistrate, it will be sent to the laboratory, they will give the report how the sample is to be taken, that is also prescribed, everything. So that procedure has to be followed, not of the BNS or new Act. So any other question, please?
We have only 2 minutes left, so we can pick up only one question right now.
Here, please. Here, by the side. This on the left of the audience. Here. I'm lifting up my hand.
Okay.
Myself, I. Kumarjit, and I am now serving as the Chief Legal Aid Defense Counsel in the recently established Legal Aid Defense Counsel system, sir. What happens is like my query is regarding Section 50 of NDPS Act, sir. You stated in your lecture that Section 50 is the only mandatory provision in the Act, and like in this, I would like to describe a scenario in which a contraband item is being recovered from on a search, whether it is on a chance recovery or whether it is on a after a source report, a recovery is made, say contraband ganja or contraband heroin or some contraband article is recovered from the vehicle. Say, and afterwards, on searching his body, making personal search of his body, no contraband is recovered, but items like mobile phone, Aadhaar card, and such other personal items are recovered. I've seen in some recent Supreme Court cases that if personal search is made, the option of being searched in presence of either a gazetted officer or a magistrate has to be given to the accused person, whether any recovery of contraband is made or not. So whether that stands true in this case or not, whether that is, I would like to confirm that if a personal search is made but no contraband is recovered, but contraband is recovered from the vehicle that the accused person is driving, will that amount to non-compliance of Section 50 or not?
Well, very good question you have put. Very good. This is actually reported case of the Supreme Court of India also on this point. The judgment is that if from the vehicle the contraband has been recovered and thereafter personal search of the accused has also been conducted, then Section 50, they say Section 50 will be applicable for personal search only if the recovery is from his or her person. Agar his search, from personal search, some recovery of contraband is made, only then it is, Section 50 is applicable, and if Section 50 is not applicable, then recovery from his body, his personal search will not be taken to consideration, only recovery from the vehicle will be taken to consideration, and on the basis of recovery from the vehicle, the case will proceed further. That's the judgment of the Supreme Court. So, if recovery is, for example, there is no recovery from the vehicle, then his personal search is taken without informing him of his right under Section 50, then some contraband is recovered from his personal search, that will not be taken, he will be acquitted in that case. But if the search of the vehicle we have found something contraband in the vehicle, and then his personal search is taken, only mobile phone or other things are recovered, not contraband, then it does not affect the case of prosecution. He will be convicted if other evidence is there.
Thank you, sir.
Thank
you, sir. Just taking advantage of this situation, just like to add another question, just simple question, it won't take much time. Other acts, say special acts like POCSO Act, IPC also has victims, POCSO Act also has victims, and many other acts have victims. But in NDPS Act, who do you consider as the victim
victim, like say a drug addict?
Very nice question you have put. Victim is entire society. It is a crime is a offense against the society, not against any individual. Entire society, because it affects entire society, entire country, not only country but international borders, another country. It is an infection, friends. Drug abuse is an infection which travels from one village to another village, from another village to the district headquarters, from district headquarters to state headquarters, from state to nation, from nation to other nations. So it goes on like this throughout the world. We have to check it, because if a person supplies drugs, he will spoil the lives of at least 100 persons, because there must be 100 persons to whom he is supplying the contraband. So victim is not 1, 2, 3. Victims are 100 persons, those along with entire families of those persons, their relatives, and those persons who will fall to the drug abuse, who will fall victim to drug abuse in future also, they are also affected by his activities. So everybody is victim in this case. Yes, any other question, please?
Okay, sir,
thank you, sir. So we have a paucity of time, please.
So we can take questions after the next session also.
Yes.
I am here.
If you have any questions, we can take up at the end of the second technical session, sir. Now, this is the time to end the first Q&A sessions. So to start the second session, respected Sir J.N. Barwalia will be the moderator, and I request Ma'am Monalisha Maibam and former NDPS Manipur and Ma'am Mangalevi to proceed with your technical session. Yes.
Presentation. A very good afternoon to everyone. My name is Monalisha Maibam, Registrar Vigilance, High Court of Manipur. I had been serving as the Special Judge NDPS for about 2.5 years. Today, I'll be deliberating on the topic, challenges in trial of cases under the Narcotic Drugs and Psychotropic Substances Act 1985, in short, the NDPS, in Manipur. Before I start with my session, I would like to remind the audience that the solemn purpose of a criminal investigation and trial is the quest of truth. As a part of the justice delivery system related to NDPS, we should be firm with our stand that no person, no offender go unpunished or escapes the clutches of law, and so that justice is served not only to the offender but also to the society at large. At the same time, we cannot forget the maxim that it is better to let go of 20 criminals than to punish one innocent person. Now, my today's presentation will be divided into the following parts. The first part, I'll be talking about jurisdictional authority and compliance. Second will be contraband management. Third, documentation and procedural integrity. 4, witness testimony and credibility, role of the judiciary, and lastly, I will be dealing with some case laws. Now, in addition to the other common challenges faced by other criminal courts, like delay in trial caused by non-execution of the warrant, non-production of material objects, and non-production of witnesses, there are certain peculiar challenges which are faced by the trial courts in relation to NDPS matter. First is not following the legal mandate under section 41 and 42 of the NDPS. Here, I would like to say that section 41 talks about arrest, search, seizure with warrant, and section 42 deals with search, seizure, and arrest without warrant. Only officials specially empowered and authorized under these sections can conduct search, seizure, and arrest in NDPS matter. This strict requirement ensures adherence to due process and prevents arbitrary action by unauthorized personnel. In this regard, I would like to show some gazette notification. This is the state government, our Manipur state government notification. The first part of the notification is about the section 41, which talks about arrest, search, and search, seizure, and arrest with warrant. Here, some officials, some gazetted officials are authorized, are empowered to to authorize the subordinate officials. For the state of Manipur, we have the deputy commissioner, additional deputy commissioner, and the subdivisional officials of the revenue department, and the director of health services, district medical officials, to exercise the power of arrest and search, and to authorize any officer subordinate to them, but superior to the rank of peon, sepoy, or constable, to arrest or search under section 41(2). 41 talks about with warrant. And next part is about the search, seizure, and arrest without warrant. Here, those officers, like all drug inspectors, all police officers, not below the rank of assistant sub-inspector, all excise police, all excise officers, not below the rank of excise zamadar, they have the power to enter any building, any enclosed space or vehicles without warrant. Here, I would like to say that I came across a case before me in which a huge quantity of contraband was recovered from a Tata truck, that also based on a prior information. But the seizing authority and arresting authority in that case was a head constable, which was clearly in violation of section 42 of the NDPS. What happens is that this procedural lapse has led to the, discharge of the accused, and despite the fact that a huge quantity of contraband was recovered, it was fatal to the prosecution, and the only proceeding that could be pursued was the confiscation of the vehicle, of the Tata truck. Similar gazetted note, it is very important to see that whether the officials who are conducting the search, seizure, and arrest are empowered by special or general under the relevant authority. This is in respect of the Assam Rifles. Assam Rifles, the gazette notification came in 8 December 2021. It says the officers of the Assam Rifle of the rank of sub-inspector and above. They are the only, those officers who are above the rank of sub-inspector and above are empowered to conduct the search and seizure without warrant of any place, of any enclosed space, of any building or any vehicles under section 42. This is Railway Protection Force, those officers who are above the rank of assistant sub-inspector. They have the power to conduct the search, seizure, and arrest of the in respect of the contraband under, without warrant under section 42. I think this is the central gazette notification in respect of BSF and SSB. Unfortunately, I could not come across any such authorization or empowerment of by central government in respect of CRPF personnel. Now, coming to the second difficulty I faced during the proceeding is about timely sampling and disposal of contraband. The legal expectation is that once the contraband is produced and sampled before the jurisdictional magistrate under section 52A, this part sampling part will be covered by my teammate, Ms. Mangalebi Sarungbam, but I'll be giving a brief overview of the said provision. 52A, even if certificates are issued, and it is expected that immediate steps be taken up for disposal of the remaining parent sample, preferably after the receipt of the forensic science report by the officer in charge or the empowered officer through the drug disposal committee. But the practical scenario is that even after the sampling and all the necessary certifications by the magistrates are done under section 52A, the remaining parent contraband are still kept and retained in the Malkhana, and this has led to overcrowding, security risks, increased chance of pilferage, and the court premises also doesn't have the enough space to store such quantity of contraband, any quantity of contraband after admitting them as evidence. So, and another point is that under section 52A, the certificates issued by the magistrate are treated as primary evidence. So there is no requirement as such for producing the whole contraband again for physical evidence, for physical production and enhancing evidence integrity. Now, as we have already learned, this sampling and weighing are to be done before the jurisdictional magistrate at the earliest, and there is a rule, narcotic drugs and psychotropic substance, seizure, storage, sampling and disposal rule in 2022. Earlier there was some confusion about this. Now the rule has come into force and it's, if I'm not wrong, it's enforceable from 23rd December 2022. Now it is mandatory to produce all the contraband for sampling before the magistrate. Earlier there was some confusion because of the standing order, one of 88, one of 89, which says that weighing and sampling should be done at the spot. Now those standing orders have been repealed, and after the coming of the rules, that sampling has to be done before the judicial magistrate. The challenges in this regard will be covered by Ms. Mangalebi, as I have told you earlier. Now, another difficulty I faced was lack of proper documentation of search and seizure procedure. The legal requirement is that officer must record information in writing in a designated register and send a copy to their immediate official superior before taking action under 42(1). In case of a search, seizure, and arrest is going to be undertaken on a prior information, then it is mandatory for the person to, for the officer to reduce the information into writing and send a copy of that information to his immediate official superior. And what I encounter is that they say only a copy has been sent to the superior, when in fact, for a copy to exist, there should be an original. But there is no, so far I have not come across any production of any original. The original is in the register, which should be maintained at the police station or the concerned department, but no proper register is maintained. Officer claim copies were sent without, but no record of maintaining the record at the PS is done. Now, time for search and seizure documentation. This time is also very important in case of search, seizure, and arrest without warrant, because you are entering some private space like building, conveyance, and enclosed space. If we have the prior information, if you have the prior information, you have to reduce that information into writing and proceed with the search seizure procedure during daytime, that is between sunrise and sunset. And if the search is going to be conducted after sunset and before sunrise, then you have to record a special reason for that, the offender is going to escape, or whatever the circumstances may be, there is chance of concealment. That fact has to be recorded in writing, and that reason for belief has to be recorded and sent to the superior within 72 hours under section 42, clause 2 of the NDPS. And the practical scenario is that recently, reasons frequently not recorded, creating procedural lapses that can affect case validity. The dispatch number and documentation of the sending of the report or sending of the information is not properly documented. This procedural lapses can significantly impact the outcome, and it can lead to the acquittal of the accused, whichever the case may be. In this regard, Colonel Singh and versus State of Haryana, in this Supreme Court has stated that total non-compliance of Section 42 is impermissible under the law, but delayed compliance with reason explained is allowed. Without answering whether it is directory or mandatory, it said that it depends on the facts of the case, but there should be, and we have amendment of the 42 which says that within 72 hours. So there is sufficient time to comply the provision. But if there is total non-compliance of Section 42, it is fatal to the prosecution. About the personal search requirements, we have already discussed about this personal search. It talks about the right of the accused before search is conducted of his person to be informed that whether he would like his search to be conducted before a magistrate or a gazetted officer. Personal search requirement needs proper documentation, though information need not be necessarily in writing. This was held in one case, Gurbakh Singh versus State of Haryana. But there should be evidence that this has been complied. But the best practice is always document the compliance of Section 50 when conducting personal search to prevent procedural challenges, and because this provision is also held to be mandatory if any recovery is made from personal search. Now, this is one of the most important point, witness requirement. Witnesses before the court, most of the time they come before the court and depose that they have signed without knowing the contents. They sign on blank papers. They don't, on the mere instruction of the police officer of the whoever was initiating or whoever was leading the search. Witnesses must genuinely observe and understand the entire search, seizure, and arrest proceeding. This must be conducted before respectable persons of the locality, as prescribed under Section 100, now 103 of the Bharatiya Nagarik Suraksha Sanhita, read with 165 of the CRPC, now 185 of the BNSS. Witnesses should be natural, independent, not someone you paid or hired. In one case, I think in one or two cases, I've come across that the police officer, they take the witnesses along with them to witness the search. And when asked, why did you go? He would say, I was paid some amount of money because I'm a Delhi laborer. So I went to conduct the search because I was promised certain sum of money. This kind of thing affects the whole veracity and the credibility of the witness. If civilian witnesses are unavailable, police personnel can act as witnesses, but the specific circumstances necessitating their role must be properly documented and must be properly shown. Why, in that scenario, why you were, there is no such rule or such thing that the police personnel cannot be a witness. But it might require closer scrutiny of their evidence. But the specific circumstances which necessitated them to stand as witness should be properly documented. Practical scenario, most civilian witnesses are merely called to sign memos without actually observing the proceeding, creating the question of credibility of their testimonies. These are some few cases like Ram Swarup versus State Government and City of Delhi, here AIR 2013 Supreme Court. There is here in the apex court stated that held that no absolute rule that police officer cannot be witness. Prosecution case cannot be doubted solely because independent witnesses were not examined. In Surinder Kumar versus State of Punjab 2020, relying on its earlier decision, Journal Singh versus State of Punjab, it stated that evidence of official witness cannot be distrusted merely for lack of independent witnesses because of independent witnesses. Absence of independent witnesses doesn't imply false implication. The apex court also acknowledged the fact that civilians are reluctant to stand as witness. So there is no, hard and fast rule, or there is no such thing that the police personnel cannot stand as witness. The only thing is that if credibility is there, if their witnesses, if their testimony cannot be doubted, their evidence can be taken into consideration by the court. Another case, State Government of NCT of Delhi versus Sunil and another 2001 case. Court should not presume police records are untrustworthy. Official acts of police are presumed to be regularly performed unless shown otherwise. So these are a few cases wherein the testimony of official witnesses were also considered. Now, the seizure memo must accurately record the entire sequence of events, including the start and end of the search, and list all the items or assets recovered. It should be signed by the person concerned. If premises is being searched, the owner of the premises, two independent officers, witnesses, the empowered officer, and the lady officer if a woman is searched, ensuring that all signatories are made aware of the purpose and content before signing. This is very important because when witnesses come before court, they should know that the purpose and why they have put the signature. Most of the time they depose before court that they do not know the contents of what they were putting their signature. So this dismantle the whole prosecution case sometimes. Here, practical scenario. Witnesses depose that they sign on blank papers without knowing the contents or merely on instruction of police. Now we have provision of 105 BNSS, which provides for video recording of search and seizure through audio. This will, I think, solve the scenario, the practical difficulty. I don't need to, I think all of you must have be aware about this proceeding provision. Field testing and documentation. The requirement is that field testing of contraband must be properly documented. Seizure of articles or contraband must be recorded in memos. Photographic evidence must be collected. Arrest procedure must follow protocol. Seizure memo requirement, prepared on spot with correct sequence of event, must include start and end time, should list all items seized, must be signed by all the relevant parties. Relevant parties are the person from whom the contraband was recovered by the seizing authority, the officer who was conducting the seizing and the arresting. Evidence handling part. Packaging the contraband must be properly packed, marked, and sealed on the spot in presence of witnesses. The documentation of the custody should be properly done. The arrested person and a seized article must be handed over to the OC of nearest PS or empowered police officer under 53. Magistrate, the sample should be produced in a sealed and packed condition before the jurisdictional magistrate for weighing and sampling. This is important because sometimes when we were magistrate also, the samples are produced in a loose and open condition, and this creates doubt about the authenticity of the subsequent sampling procedure. And inventory should be prepared by the concerned officers, by the OC or the empowered officer under section 53. Arrest requirements, post-arrest procedures must inform ground for arrest. Fact of arrest must be intimated to relative friend. Endorsement requirement, endorsement should be made on the arrest memo by the concerned persons. It must be done before the witnesses. Most of the time I came across that in some cases that they have only mentioned that a relative has been informed without even stating the name of that witness, the relative. In a reporting requirement, the report of the search and seizure must be sent to the immediate superior within 48 hours under section 57. Date and time of the report is important to show due and timely compliance of section 57. These provisions may be directory or mandatory. Not coming to that part, but if certain procedures are being prescribed for the law enforcement agencies, then it should be our endeavor that these are followed to the letter and spirit. Custody, storage, and chain of custody. The OC of DPS or godown in charge must ensure safe custody of seized contraband in designated godown, verifying quantity and the weight. Documentation part. Register must be maintained at godown, malkhana, or PS. Most of the time, they say that register is there. They are not even sure whether register is maintained at the PS. They will only show the receipt the go down receipt is there, go down receipt is produced, but when asked by the defense that whether you have, this is only a receipt, whether there is, in the receipt itself, there will be mention of the go down entry number, but they are not sure that a register is maintained. Movement of this seized contraband sample must be properly documented if pre-trial disposal is not done, if certification under section 52A, we have talked about earlier, the certificates issued under that provision by the jurisdictional magistrate are considered as primary evidence. But, and that is after the disposal, if disposal has been done. But if disposal is not done, then the physical evidence is also primary evidence. And proper documentation that should be there to show the proper chain of movement, the chain of custody of the seized contraband. Another most important criticism faced in trial of Nd&Ps matter is that only the small-time players or the peddlers who are involved in the whole scenario for few monetary gain or few personal benefits are the one who have been made to face the trial or investigation, whatever. And the large scale operators or true kingpins are always left out. Because investigation are not properly done, the investigation only investigation is only done to reach, not able to reach up to the kingpin level. They are done only to reach only to catch the small time players. And investigation of NDPS matter, only the statement of the accused is recorded. And these statements, they have no legal value, they have no value in the eye of law. So proper investigation need to be done so that we can reach up to the persons who are involved in a larger scale, who are behind the scene. In this regard, we can explore section 64 of the NDPS, which section 64 provides for power to grant immunity from prosecution. The central or state government may, if it is of opinion that with a view to obtaining the evidence of any person appearing to have been directly or indirectly concerned in or privy to the contravention of any provision of this act or of any rule or order made thereunder, it is necessary or expedient to do, tender to such person immunity from prosecution for any offense under this act or under the IPC or any other central act or state act, as the case may be, for time being enforced, on condition of his making a full and true disclosure of the whole circumstances relating to such contravention. So I think that if we can explore this section 64 of the NDPS, we will be able to catch hold of those big players. Now coming to the last part of my presentation, the judge's role in uncovering truth in NDPS matter. One of the personal difficulty I have faced during the trial, as a role during the trial in NDPS matter, the role of a judge is, in all criminal trial, is to find out the truth. To achieve this end, court is given ample power under 311 CRPC, 348 BNSS, now BNSS, read with section 165 of the Indian Evidence Act, 168 of the BSA. Sometimes when contradictions in the testimony of witness are recorded by the defense during cross-examination of the witnesses, the prosecution is not usually interested to clear the contradiction by way of re-examination, or even when the witnesses turn hostile or not support the prosecution case, the prosecution failed to effectively ask questions in the nature of cross-examination to extract the truth from the witnesses. So what in such situation, the court, without stepping into the role of anyone of any side, by maintaining the neutral position, can ask relevant questions to find out the truth. So while doing so, I have faced one remark in the open court that I was siding with the prosecution, when in fact I was asking the questions to know to find out to clear the contradiction, or just to find out the truth. This was also one of the challenges I faced when I was discharging my role as NDPS judge. (348) of the BNSS says any court may at any stage of any inquiry, trial, or other proceedings under this Sanhita summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and examine or recall and re-examine any person if his evidence appear to be essential to the just decision of the case. This is a procedural part. Another provision of very importance is 168 of the Bharatiya Sakshi Adhiniyam, which is judge power to put questions or order production. The judge may, in order to discover or obtain proof of relevant fact, ask any question he considers necessary in any form at any time of any witness or of the parties about any fact, and may order the production of any document or thing, and neither the parties nor the representative shall be entitled to make any objection to any such question or order, nor without leave of the court to cross-examine any witness upon any answer given in reply to any such question. So these are some of the provisions which empower the court to extract the truth. So the role of a judge in all criminal trial is to find out the truth. But this is very important and a crucial role, because we have to maintain a neutrality and not step into the role of either side. Some case laws which I've come across and I find of importance. Durgabai versus State of Punjab, Babu Bhai Odhabji Patel versus State of Gujarat. So in this case, it was the differentiation between the general information and the specific information was made. They distinguished the difference between general information and specific intelligence. Specific information. Section 42 talks about specific information, not just general information that a contra. If there is no specific information, then there is Section 42 is not applicable. General information about smuggling that leads to nakabandi cannot be equated to receipt or information under Section 42. For Section 42 to apply, there should be a specific information. Chance recovery. If narcotic drugs are recovered during a search in connection investigation of other offenses under CRPC provision, this we have already discussed, but compliance with 50 is not required. Post-recovery procedure, after the chance recovery is made, as soon as the chance recovery is made, the empowered officer should proceed with the investigation as per the NDPS law. And if he is not empowered, then he has to hand over the case or inform to the empowered officer. Gazetted, this was covered by our esteemed resource person in the previous session, Srinivas Gaud versus here gazetted officer, whether if he personally receives the information, whether he is required to report to his send a copy to the official superior. The Supreme Court clarified that gazetted officials are not required to report to their superiors under Section 42, Clause 2, when they carry out arrest, search, or seizure on their own. Gazetted officers have the power to authorize juniors to proceed with section. They are the source of authorization power and enjoy special positions under NDPS. Because this is pertaining to Section 41. 41, some gazetted officers are empowered for search, seizure, seizure and arrest. they are a source of power, so they did not comply Section 42. The key points from this Supreme Court case is there is no bar in statute for gazetted officers to carry out functions themselves. When acting on their own, no reporting to senior is required. Section 42 clause 2 apply to officials below gazetted rank acting without authorization, and when search and seizure is to be made without warrant, would be anomalous to require reporting from those who can authorize others. Section 40 compliance, total, we have already discussed. Colonel Singh versus State of Haryana, it says total non-compliance is impermissible, but delayed compliance with satisfactory explanation is acceptable. But whether there is subsequent, whether there is adequate or substantial compliance is a question of fact. Applicability of Section 42. The officer must have reason to believe from personal knowledge or information received about the contraband. When Section 42 doesn't apply, if action is going to be taken, this is about chance recovery. If the action was taken without any personal information or any prior information, then Section 42 would not be applicable. State of Punjab versus Baldev Singh, CRPC is applicable if so far as it's not inconsistent with NDPS. When an empowered officer conducting investigation under CRPC discovers narcotic drug, they must follow NDPS Act provision from that stage onward. Non-empowered officer must inform empowered officer under the NDPS. This is about chance recovery. Now, Balbir Singh, when police act under CRPC provision while investigating other offenses, non-compliance with Section 102 CRPC cannot be ground to reject prosecution outright. Such non-compliance affects appreciation evidence. It only affects the credibility of the evidence. It does not vitiate the whole trial. Section 50 applies only from for search, for when a recovery is made from personal search. Is conducted for when search is conducted for investigation of other offenses and a chance recovery of the contraband is made. Section 50 doesn't apply. Search is not of the person but of something carried in his hand, from a bag or a container, then Section 50 will not apply. So Section 50, the requirement of Section 50 need to be, may not necessarily be in writing, but it is always better to document it. This is the same thing. Presumption that we have in Evidence Act that all the official work are duly performed, it doesn't apply in NDPS because the compliance has to be proved. This was in the state of Himachal Pradesh versus Prithi Chand. Evidence collection and procedural violation, admissibility of evidence. Evidence collected during investigation in violation of statutory, this is a general law that it doesn't vitiate the trial. Discharge and non-compliant, even if search violates Section 50, discharge is not proper. This already sir has pointed out that we need to proceed with the trial, not discharge the accused at the very start of the trial. Section 52 and 57, directory, not mandatory. Non-compliance must be examined for prejudice to accused. We have to see whether any prejudice has been. So these are some provisions, some decisions of Supreme Court which I have come across that when seals of samples are found intact and variation in weight is minimal, tampering plea is rejected. Forensic evidence, when lab reports show samples received with seals intact, no infraction, there is no infraction is there. Unsealed contraband kept in unsealed condition for about to create doubt. Some section, Bharat Ambale, this is related to sampling part. Hira Singh sir has already discussed earlier. Only the neutral, earlier the position was that the neutral substance should be excluded. The offending drug should be only considered for assessing the quantity, whether it is small, intermediate, or commercial. We have earlier the position was that the offending drug, the weight of the content of the offending drug should be the only factor to be considered. But Hira Singh versus this decision of the Supreme Court, three-bench judge of the Supreme Court, says that neutral substance mixed with narcotic drug must be included. Means the offending and non-offending should be clubbed together, should be taken together to assess the quantity of the contraband. This is about possession, about the burden of proof. Once possession of contraband is established, the accused must prove they were not in conscious possession. There was another decision prior to this, Bhola Ram, if I'm not wrong, Bhola Ram versus, says that the knowledge part should also be proved by the prosecution. But now, it's not now the Baldev Singh versus State of Haryana, the position is that once possession of contraband is established, the accused, burden lies on the accused to show that he has no knowledge or he was not in conscious possession of the contraband. Under section, this is under section 35 of the NDPS. This burden can be discharged by raising doubt using the prosecution's own evidence or by presenting their own evidence. If the prosecution evidence itself suggests the accused's lack of knowledge or intent, the burden stays discharged. It means that the accused need not produce his own defense to prove that he had no knowledge. He can use the prosecution's evidence as well to discharge the burden. But the burden is on the accused to show that the mental part is not there. If physical act of the actus reus, the possession is established, then the burden lies on the accused. The reverse burden is there, that he has to prove that he had the absence of mental culpability is on the accused. Lastly, this is the last part of my presentation. The purpose or objective of the NDPS is to balance the conflicting interests of making sure that no culprit or offender escapes the clutches of law and the society is protected from drug penance on one hand, and on another hand, of protecting the right of the accused by providing procedural safeguards, which the Apex Court has held that some of the safeguards to be mandatorily followed in view of the stringent punishment in the NDPS. So as a part of the law enforcement agency, it is our duty that this procedural safeguards enshrined in given in the NDPS Act should be followed in letter and spirit. Thank you.
Good afternoon, everyone. Thank you to my seniors, Madam Mona Lisa. I'll be continuing a portion of which she introduced. Before I begin my presentation, I would like to request everyone sitting in the back to please wake up if you have fallen asleep after a good lunch, so that I request for all's indulgence. My name is Mangalebi Sarungbam. Presently, I'm holding the charge of post of Joint Registrar Judicial, Manipur High Court, along with the in charge of Chief Justice Research for Center and Planning, come State Court Management post right now, presently. But today, I stand at this podium before all of you as a former Judicial Magistrate First Class Moray. I was stationed at Moray from 2021 December, very shortly after my training, my first substantial posting, until the conflict broke out in May 2023. So today I'm going to be presenting in a very interesting topic, that is Section 52A. So in this regard, before I rush to the presentation, I thank my parent High Court, Manipur High Court, Manipur Judicial Academy, to the Director, Joint Director, Sir, to Manipur State Legal Service Authority Member Secretary, Sir Alec Muiva, to all my seniors, my colleagues, my juniors, to all the law enforcement agencies present here, everyone from the Manipur State Police to the CRP to the Assam Rifle, to all the other departments from forensic science, to all the law students, to all the professors from various colleges of Manipur. I sincerely thank you and I seek all your indulgence because I will be briefly, I won't take long, I'll be briefly sharing my experience of what I did during my tenure at Moray. So, I'll begin with my slide. I need assistance, please. Next call. Okay. So, my topic is confined to section 52A. The purpose of 52A is very important because we all, that is all the law enforcement agencies, not only the police personnel who comes into picture with the accused person at first instance, not only the magistrate courts are important, but we need the cooperation of the FSL, of various other stakeholders who are involved because we are going to be preserving, creating a primary evidence, which is going to be the foundation for the trial of an accused person in NDPS cases. So section 52A, I will not read out the entire section, but I will just briefly go through the points. Section 52A has 4 subsections, and the purpose of the importance is emphasized in subsection 4 of 52A. 52A subsection 4 says that notwithstanding anything contained in the Indian Evidence Act, that is the former, now we have BNSS, every court trying an offense under this act shall treat the inventory, the photographs of the narcotic drugs, psychotropic substance, controlled substances, or conveyance, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offense. And here comes the importance of 52A. So, once the drug is seized, the first thing that I'll be briefly explaining 52A, then I will go to the rules which will come into picture later and which will govern the entire sampling procedure. So, by virtue of 52A, subclause 2, which says that once the seized suspected contraband, the seized suspected contraband is seized by the IO and it is forwarded to the concerned OC or the empowered officers under section 53. Thereafter, an application is made to the magistrate, that is us, Judicial Magistrate First Class Courts across the state of Manipur. They have to make an application for the purpose of certifying the correctness of the inventory so prepared. Second is taking in the presence of the magistrate photographs of such drug substances or conveyances and certifying such photographs as true. And third, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. So, I was serving at Moray at a very interesting period because that intervening period when I was serving, the existence of the rules of 2022, which is annexed, I'm sorry we don't have the books here. I would appreciate if everybody can refer to their mobile phones and open it, Google, and that will be more helpful to go through the presentation. So, as per the rules of 2022, that rule came into effect, like my senior said earlier, it came into effect only in 23rd December 2022. So prior to that, there was a confusion regarding whether the seizure and sampling procedure is to be conducted before which magistrate. So many confusion has been created, and accordingly, prior to the coming of this 2022 rules, there were 4 standing orders which are mentioned in rule number 29 of the rules of 2022. There were 4 standing orders. One is the one of 88, 5 standing orders. One is the one of 88, one of 89, 2 of 88, and another one in 2007 and 2015 respectively. So these rules created a confusion where the seizure, sampling procedure is to be done before the magistrate, whether the sampling is to be done on the spot, which magistrate, whether it will be a judicial magistrate or a executive magistrate. So these entire standing orders have been repealed by the coming of this act, this rule that later came into picture, that is any assistance? The narcotic drugs and psychotropic substances, seizure, storage, sampling, and disposal rules of 2022. With the coming of these rules, all the previous standing orders have been repealed, and now from 23rd December 2022, we are to follow these rules of 2022. So I'll briefly, it will be very quick, I will briefly go through the relevant provisions which are of importance to us, and thereafter I'll be sharing my experience of what I have done in Moray and how we can make improvements altogether. So basically under the rules, we have like, you please come and help for me now. Next, I'll be speaking the rules now, and then you keep playing together. So these rules are categorized into 5 chapters. The first chapter deals with preliminary, second chapter deals with seizure and storage, third chapter deals with sampling, fourth chapter deals with disposal, and fifth chapter deals with miscellaneous. I'm going to be focusing only on the sampling part mainly, and then I'll be sharing my experiences of what I did at Moray and what amendments we need to do in the future with the coming into effect of this 2022 rules. Please go to this one. Section 3, the rules. Next. Rules. Next. Yeah. So. Next. Back. Yeah. So, Section Rule 3 of this Rule 3 of the 2022 rules deals with the sampling part, but before that, the police personnel, when after seizing, they have to produce the seized suspected contraband before all the magistrates in a very particular way, because it starts from the very beginning when the suspected seized contraband is seized from the spot. So in that regard, rule number 3 says that when drugs, the suspected contraband is seized, we have to first categorize whether it has been seized in the proper container format or it is in the loose seal. In case it is seized in the container format, then the police personnel, they have to first give a numbering of all the, for example, let's say we have seized around suspected 10 soap cases of brown sugar, which I'm sure any personnel from Moray police station we have? Any person? Any representative from Moray PS? What rank would you be? Sub SI. Okay. So for instance, I will focus my experience with Moray because I have done mainly with the Moray PS. So when 4 suspected soap cases are seized, first the concerned IO does it before producing to me. I have seen and observed, which is also in the rule, is that they number. Soap cases, 10 soap cases are there. Then not only on the packets which is inside, the brown sugar, not the packet only above that, but even on the soap cases also. The container also, very important at the stages of the trial later. So they number the soap cases properly, but in case a seal, the loose seals, for example, we have seized like 2 soap cases which are properly sealed, and the another third packet, half is open, which has been a cases also where half opened packets have been sealed. In that cases, what the police personnel we request is that, and as per the rule also, we have to transfer the loose contraband, suspected contraband, in a proper packet, heat packet, or maybe a container, and then it has to be numbered, it has to be given the details as to what was the time of seizing, how much amount is there, like that, and then it has to be produced before the concerned magistrate. One question that I also faced myself at a very initial stage of my experience in sampling is that what happens, there are certain categories of contraband drugs which was produced before me, and sometimes there are a classification of how many amount is to be taken for sample. For example, next slide. Yeah. For example, Rule 11 talks about how much of quantity is to be drawn for sampling. So in case of opium, not less than 24 opium, ganja or charas, these for this category, not less than 24 grams. Not less than 24 grams. In case of in case of like tablets, for example, WI Yaba tablets or SP tablets, a stripe of 10, the classification is given in the back of the schedule of the act, but it says that in case of tablet nature, that it should not be less than 10 tablets. In case of powder format, it should be not less than 5 grams. So these are some specification that has been provided in the scheme of the schedule to the act, and accordingly when sampling is done, we have to draw the samples according to the specified grams. However, there are certain peculiar cases where this is only, for example, 3 grams or very, very lesser than like 20 grams of ganja. In that case, the question is answered in rule number 3, subclause 5. Sorry. Rule number 11, subclause number 3, it says that in case where seized quantities is less than the required for sampling, the whole of the seized quantity may be sent to the FSL. So next, when the police, next will be, I'll jump to this one, chapter number 3, that is the sampling from rule number 8 to rule number, rule number 15. In case of sampling, what we have been doing before the coming into existence of these 2022 rules, as well as per the standing orders, are almost similar, except the fact that the new insertion and clarification expressly that the sampling has to be done before the judicial magistrates. Firstly, the IO has to make an application before the concerned magistrate, and after that, the sampling is to be drawn in the presence of the magistrate, the accused persons, and the witnesses. So far, my experience is concerned in terms of my experience in More, there has been no independent witnesses who were not from the police department. It has always been from the police department. So, Madam, continuing to the previous, that independent witness, I just wanted to add that during my experience, there has been no witnesses who were not from the police department. Everyone was from the police department for the reasons of what was explained before. After the drugs are produced before the magistrates, the nature of the drug has to be properly examined. Even after the police personnel have produced before us, before the magistrates, we see that what is the nature, what is the color, what is the order. For instance, let's say in case of WI tablets, as I'm sure that a lot of experienced people are sitting amongst us, there has been instances where there are 2 colors. One is orange color and one is pink color. So the resource person, sir, has yesterday taught me that even if there is a different, the color is different, there is no harm in mixing all the WI tablets together, but later I will demonstrate in my slides that I have, because of the large quantity, and that time, since I didn't want to take the risk as it was my first time, so I have done the sampling of the same WI tablets, but of only different colors separately. The rule is very beautiful. In rule number 10, it says that if, say, rule number 10, subclause 1 says that if only 1 packet is seized, then we have to draw the samples from that packet. If less than 10 packets are also seized, then we have to draw samples from each 10 packet. And if there are more than 10 packets, rule 10, subclause 2 says that if there are, like, say, 50 soap cases is seized, then we bunch those soap cases into 10 categories, and 10, we put it into the one main parent packet. After that, we draw samples from each. But I will later, of my experience, which was mentioned earlier about the 500 crores seizure of the brown sugar in the year 2021, I'm going to say how these rules are a little of help at the time of taking care of such a gigantic amount of seized contraband. When drawing representative samples, though the rule says that the same amount, for example, after seizing all the contraband, we put it in the, I'll illustrate, but I'll just go through the rules once, and then I'll go through my slide of what I have done, along with the photographs, and I'll express properly. But as per the rules, it says that equal amount of the original and the duplicate has to be extracted from the parent sample. So in this regard, even though it is done in the presence of the magistrate, I would like to seek the attention of the investigating officers in NDPS cases that kindly make sure that it is not less than the amount that is specified in the act. Because in many of the cases, sometimes, let's say 5 grams, we do exactly 5 grams. So it says that not less than 5 grams. It will be advisable if we take more also. In order to avoid any kind of discrepancies in the future, I have, in my period, we used to request that 6 grams instead of 5 grams is done, or 1 or 2 gram extra is inserted in the sampling, so that in case there will be no fault on the part of all of us while making the evidence. Rule 11 deals with, Rule 11 deals with the quantity to be drawn from the sample. I think at the cost of repetition, I'll say again that in case of the opium, ganja, charas, where a quantity of not less than 24 grams shall be drawn for each sample, and in any other cases, not less than 5 grams shall be drawn for each sample, and the same quantity shall be taken for the duplicate samples also. Going on to the next, it says that once, as soon as the samples are being certified by the concerned magistrates, the representative sample drawings has to be sent to the forensic laboratory as soon as possible. Now, I'm coming to the rule number 13, 14 and 15, where I would like to invite the special attention of the investigating officers as well as the FSL forensic department representatives. Because as per the new rules, it says that for the expeditious test, once the sample is taken, it has to be sent to the laboratory as soon as possible. For rule number 14, the chemical laboratory, after the samples are sent to the chemical laboratory, the chemical laboratory shall submit its report to the court of magistrate with a copy to the investigating officer within 15 days from the date of receipt of the sample. There is a proviso also, in case of qualitative analysis, there is a distinction between qualitative analysis and quantitative analysis. In case more time is needed also, in that case also only another 15 days is provided. But here, I would like to draw the attention because I don't know what is the existing, it's been more than 2.5 years that I have not done the sampling, and meanwhile, what is the practice of the sending of the memo of the chemical analysis by the laboratory concerned to the IO or through the IO to the court later, I do not know, but as per the new rules, I would like to draw your attention that the chemical analysis report has to be sent to the court by the concerned department within the period of 15, from the receipt of the sample within 15 days. Okay. So lastly, in chapter 4, we have the disposal chapter. In this, I'm not going to go through the entire rules, but I'll just highlight only 2 important rules under chapter number 4 of the disposal, that is rule number 17 and rule number 18. In rule number 17, it says that officers who shall initiate action for disposal. Here, I would like to I just discovered, even I myself, when I read the act again, rule again and again, I also just noticed myself here a new thing, that is application for disposal during my period and experience at Moray. It used to be made at the time of production of the accused person. There used to be 3 prayers, remanding of the accused person. After that, prayer for drawing the representative samples, and third is the disposal. Disposal application used to come at the time of the production of the accused person along with the sample only. But in rule number 17, it says that any officer in charge of a police station or any officer empowered under section 53 of the Act shall initiate action for disposal of NDPS after the receipt of the chemical analysis report. So I would like to bring to the notice of all the law enforcement agencies here regarding this provision. Okay, now I think I have briefly covered the rule, but now I would like to share the important, my experience. So these are some practical documentation I've taken with the permission of my present NDPS court madam, and this is how I had prepared during my time, so that it will be more besides the rule what was done, so that it will be more clear. This is along with the application for drawing representative samples. This is the inventory that is mandatory and that is required under form number 4 of the Act annexed. The inventory should contain, one thing initially I noticed is that the IO used to write only the amount of the seized suspected contraband. But this inventory should also contain not only the seized suspected contraband, but also the conveyances. Like if a vehicle is seized, or let's say the gunny bags, along with, there are cases where a lot of fruits or a lot of rice or in the gunny bags where the contraband was seized. So even that has to be included in the inventory. Then along with the inventory, when preparing the photographs, initially there is a separate form which is in the inventory itself, where certification in form number 4 and form number 5, the inventory along with the certification by the magistrate, format is already given here, which is reproduced here, but I'll show again. But along with that, this is what we prepared in Moreh. I do not know about the other police stations, but we made the index manually only because of the paucity of time there, and no electricity was there in Moreh almost all the time. So the index of the photographs that was taken, on the right side of the photograph, we can see that there's the first nature, the way it was produced before me, before the sampling was conducted. Then we had taken photographs step to step. After taking out the seized contraband, we had taken out the suspected contraband. And then we had, I think the sequence is a little broken, but before we put the seized suspected contraband, after mixing it into a homogeneous mixture and putting it into a plastic parent packet. Even the plastic parent packet, it's also properly weighed, because there's always a discrepancy later in the trial, which I'm not very aware of, but madam has taught that there are sometimes from commercial to intermediary quantity to categorizing when conviction time comes, and there is a issue of classification of the intermediary to commercial quantity. Even 5 grams makes a difference. So we make sure that the parent packets in which we are going to mix the homogeneous mixture is also weighed properly for the parent packet as well as the duplicate. Like this, we have done it Moreh like this, and then this was a case of, this is the case I was referring earlier, when we had seized a huge amount of the WY tablets of different, everything was same, the nature, order, color, smell, everything was same except the color. The color, one was orange and another one was pink color. I'm not sure if it's very visible, but on the left side is the orange color and on the right side is the pink color. So even though a resource person, sir, has said that there is no harm in mixing all the Cs, even though there's a difference in the color, but then I did it in a separate cases, and separate samples were drawn from these 2 separate parent A and B samples. Then after the entire process of drawing of the representative samples are photographed, a little sequence is messed up here, but we number, we take out the representative samples from the parent sample, and then we number, and then we weigh also, and then after that, everything is packed in the sealed envelope at the last. This is the sealed envelope. Zoom to where address is it? Zoom to where address. So in the envelope, the important here I would like to highlight a lot of sometimes mistakes were made is that in the envelope when we are finally sealing the samples, what is required on the envelope is that entire proceedings is conducted in the presence of the accused person. In cases where accused person is not there, the fact is recorded in our sampling order, and then that is how we proceed. But where the accused person, it is very compulsory that we get the signature. Sometimes entire proceeding has been conducted, sampling in the presence of the accused, and then we find at last that the accused person's signature was not obtained. I have made that error sometimes because of the confusion and the chaos sometimes it brings with the sampling procedure. But last in the samples, signature of the accused will be required. Witnesses where two witnesses, mainly I've seen that the police personnel, like maybe the driver or the constable, even they were very reluctant, but then they didn't have a choice because there were no independent witnesses available. So they had affixed their signature on the envelope. Then the signature of the magistrate before whom the sampling is conducted, and of course the investigating officer. After that, as a precautionary measure and in order to avoid any kind of long delays of arguments in the trial court later, this sealed envelope, on the back side of it, what we did is put the facsimile. Every police station has their own wax facsimile. We had fixed the facsimile, and above that facsimile, it is not visible here in the photo, but we put around the sellotape above this facsimile so that this facsimile is also not broken. Because sometimes the facsimile, in the process of transferring and transmitting, the facsimile gets broken, and then there is a question again during the argument that this is not the right facsimile, it's been broken, and a lot of other factors arises. Yes, and this is one of the most important part that I learned through experience, though it is nowhere mentioned in the rule, subject to correction of course. In this last paper, what I have done is that the seals, because in order to preserve the chain of custody, the seals of all the important stakeholders while conducting the sampling procedure is very important. So what we did is, we had requested the OC seal, because the OC is the concerned person who will be storing the seized suspected contraband in their respective godowns or malkhanas. Then the IO, investigating officers, along with their seals. The seal is very important, of which I think our resource person sir will be deliberating later. The seals of the OC, the seals of the IO, the judicial magistrate's seal, along with their respective signatures, and the facsimile. So these were the compact documents that we were observing while conducting the sampling procedure. This is another case. The previous one was for the tablets, WY tablets. This one was for the seizure of the brown sugar in small quantity. When small quantity is seized, rules that is provided under rules number 2022 rules is very much perfect. But now I'm going to end my presentation because the larger question will be answered by our resource person and my senior madam sitting here. Last, shall I say? This picture, this is the most interesting case that I have encountered in my life. This is the case because of which I got very interested in NDPS, and I'm having the opportunity to be interacting with everyone. This is the case that does not fit in the rules of 2022 Rule 10. And my resource person, my seniors sitting here, who have been former judges of NDPS court, all the staffs, all the law enforcement agencies from Assam Rifles, CRPF, Manipur police personnel, I request everyone, in case there is a future seizure of such huge, gigantic amount of health like this, how we are going to be dealing with it and what are the precautions we need to take, because for conducting this, it took us around 4 or 5 nights and 6 days. And I think at that time, the police, law enforcement, additional SP, brother Amrit, I do not recall, but he was there, and sir, late O.C. Anand sir was there. It was a very big challenge to take care of this seizure. And a lot of questions is asked with this picture. So I think my presentation is very brief. I'll end here. Thank you so much for your indulgence. Now my seniors will take over.
Thank you so much, ma'am. Now we can start the Q&A session.
Well, friends, the source persons, Srimati Mona Lisa, Mavam, and Mangal Dei has beautifully described the flaws in the investigation and the sampling of the narcotic of the seized articles. Friends, there were 2 standing orders. They were 1 of 88, 2 of 88, 1 of 89 by the Narcotic Control Bureau. There were 2 notifications of the Government of India, Ministry of Finance. They were of May 2007 and January 2015. So these were the notifications regarding sampling, how this is to be done, and how seizure memo is to be prepared. Everything was there. But in Mohanlal case, this Union of India versus Mohanlal 2016 case, very important case, the Supreme Court of India said, yes, all the samples should be taken in the presence of the magistrate under section 52A. All, whether they are for disposal, whether they are otherwise, they should be taken, and then they directed the Government of India to frame rules. Under that judgment, this 2022, those are by 2022 rules have come. Under these rules, yes, deposit in godowns, first it will deposit it, then sampling, application to the magistrate. It says only the samples should be taken in the presence of the magistrate by moving this application under section 52A in all cases. Now, whether this rules will stand the test of the time, I can't say, because when it is challenged in the Supreme Court by somebody, there is a difference between section 52A and other sampling. 52A is only for drugs which are for disposal. The section says, section 52 says disposal of seized narcotic drugs and psychotropic substances. Only for that section 52A has been enacted. But here they have made these rules and they have made it compulsorily mandatory that the samples should be taken in the presence of the magistrate. Now, for this purpose, the rules itself provides the forms. Form 1, forwarding memo to the godown by the seizing officer. Form 2, acknowledgement by the officer in charge of the godown. Form 3, register of material received in the godown. Then Form 4 is inventory of the seized material. This is to be prepared by the officer in charge of police station. Then 5th Form 5 is application for disposal of seized narcotic drugs to the magistrate, and then certificate by the magistrate under subsection 3 of section 52A. So this is now the rules which are in force, and according to the rules, all samples are to be taken before the magistrate. Now, how the samples are to be taken? They should be representative samples, as Madam has spoken, representative samples. Now, the recoveries of 500 crores of brown sugar, 500 crores, too much. And it was so huge that 5 nights and 6 days were taken to take out the samples from that seized article. So this problem was never anticipated while preparing these rules. So on the spot, what are the difficulties of the IOs? They are never imagined. So, but friends, thereafter, 2 judgments, very important judgments have come from the Supreme Court. One is Hon'ble versus State of Chhattisgarh. It is 2025 judgment. And second is Yusuf Asif versus State, 2023 judgment of the Supreme Court of India. And in both the judgment, they have diluted to some extent this provision. They say it has been held the procedure prescribed as standing order rules in terms of section 52A of the NDPS Act is only intended to guide the officers and to see that a fair procedure is adopted by the officer in charge of the investigation, and as such what is required is substantial compliance of the procedure laid down. Substantial compliance. Mere non-compliance, very important, this judgment says, mere non-compliance of the procedure under section 52A or the standing order or the rules, these 22 rules, thereunder will not be fatal to the trial unless there are discrepancies in the physical evidence rendering the prosecution case doubtful, which may not have been there had such compliance been done. Courts should take a holistic and cumulative view of the discrepancies that may exist in the evidence adduced by the prosecution and appreciate the same more carefully, keeping in mind the procedure lapses. So, again, here also, it is not mandatory in a way. These rules are not mandatory. In this judgment, they have said that the discrepancies are there, they have to be seen and they have to be reconciled by the courts. Whether it will affect the case of prosecution or not affect the case of prosecution, and I am sure someday a larger bench will give some other judgment that these rules are only applicable for 52A cases, not other cases. Sampling can be done by the gazetted officer or by on the spot also, as it was being done earlier. So, but till these rules are there and no such judgment comes, we have to comply with these rules. Now, there are presumptions, as Madam has said, under section 35, 54 and 56 of the Act, which presumptions go in favor of the prosecution, and accused has to prove that he did not have the mental, he was not having these presumptions have to be rebutted by the accused, So now question and answer session. If there is any question, then that is most welcome on sampling or on any flaw on investigation. That is most welcome. Thank you very much.
So among the participants, do you have any questions? So please ask the questions to our resource persons directly.
The first query was about anticipatory bail. Well, there's nothing in the rule that, there's nothing in the law that anticipatory bail is not applicable to the NDPS matter. But the thing is that anticipatory bail is an extraordinary relief. And for that, extraordinary circumstances has to be produced, and it depends on the facts of the case. Not only that the person, the applicant, has reasonable apprehension of being arrested is not the only ground. In order to avail this extraordinary relief, especially for NDPS matter, as we all know, as we all can agree, that it is a very serious offense, providing stringent offense, and we cannot, anticipatory bail cannot be given as a rule. So it depends on the facts of the case. And to the...
Could you please repeat the second question again?
The second question is, ma'am, if the arresting authority or IO of the case fails to furnish submit the charge sheet in time, it is statutorily valid. Most of the state police fails to submit the charge sheet, even for the commercial committee also, but NCPD or NAP submit the charge sheet in time. So if they fail to submit,
well, I would like to say that there is no law as such to punish any police officer who failed to file this charge sheet within the time limit as given in the law. The only thing, the only consequences that entail is that the accused gets default bail. The law expects that he completes the investigation during the time limit before the statutory bail is entitled to the accused. But there is no law that we can punish the concerned police officer who failed to file the charge sheet.
Ma'am, please don't mind, as a spokesperson of this session, please can you tell us that is there any threat law convicted by the court in Manipur so far till today?
I do not, during my tenure, that's what I was addressing in today's presentation as well, that this is because the investigation of NDPS cases in Manipur ends with the arrest of the peddler only. It cannot reach to the larger, to the kingpins. If the material is not produced, if the evidence is not there, we are helpless. We cannot punish on mere assumption because burden is beyond reasonable doubt always. And if the investigation is properly done to reach the kingpins, like I have already shown the sections, what was that? Tender of pardon, provision, immunity to extract the information from the accused, and then we can proceed with the investigation to reach to the kingpin. But if the investigation, 64 of the NDPS, if we can explore, if we can, explore this provision, then I think we can reach up to the kingpin.
Yes, just I will add a few words. Friends, the conviction rate in India is very low. And 1 year in Japan, the conviction rate went down from 98% to 96%. Commission was there to inquire into why 2% more innocent persons have been sent to the courts. That is the standard of those countries. But in our country, the person is languishing in the jail, and after 5 years, we say no case is made out, he is acquitted. So this is what is the law in our country and what is the law in Japan. That is the difference. Secondly, as far as anticipatory bail is concerned, 2 certificates are to be given by the judge granting bail under section 37. They are that he has not committed the offense. That certificate any judge can give if there is no evidence. But second is that he will not commit any offense while on bail. So in anticipatory bail, which judge can give this guarantee that he will not commit offense while on bail? So that's the reason anticipatory bail is not granted under this act. So, but friends, I may tell you, if it is a small quantity, the accused has to be released immediately on arrest by the IO himself. If he does not release him in small quantity, then the magistrate has to ask him to give bail and he has to be released. But in intermediate quantity, bail can be granted as in other cases, discretion. In commercial quantity, bail can't be granted because 2 conditions which I have read, they have to be satisfied, which is very difficult. Second certificate is very difficult to be given by any judge, whether he is a trial judge, whether he is a High Court judge, whether he is a Supreme Court judge, that he will not commit any offense while on bail. That's the, thank you.
So my question, first question is whether the user should be treated as a criminal or should be treated as a victim. This is my conclusion. The second question is, you have mentioned that here are some message never in India. That if a person is found in possession of a drug in small quantity, they cannot be discharged under Section 27 if exclusively applied to consumption. But I want to know that Section 64A, Section 64A is an case that immunity from protection, prosecution, immunity from prosecution to ethic, prevailing treatment. That harassing and harassing versus never is conducted is Section 64A. So please explain
my opinion in this regard is rather radical. I think that all addicts, regardless of the quantity, they are to be treated as victims. They are not, they need to be treated. They need to be handled, proper care and treated in an institution. They are not to be considered. That's my personal opinion. But law as it stands today, there is, consumption is an offense. Consumption of narcotic drugs and psychotropic substances is an offense. Can you please repeat the question and let us know who is speaking? We can't see.
Sorry. Can you repeat the question?
Where are you?
Can you raise your hand?
The question is addressed to whom? No. Okay.
So the question is, Manipur is a drug-prone area as well as a region of the Golden Triangle connected to Western South America. So what are the challenges in investigating the Nd&Ps cases involving international drug trafficking networks? And additionally, the question is, will it be considered that the justice is served and Nd&Ps is effectively applied if conviction is only against the vulnerable third party, not against the drug lords? And will it be considered that the investigating authorities or police personnel has not properly performed their delegated powers if it has not been convicted? Thank you.
I can't make out what was the question. You have given a long statement, but I can't make out the question. What was the query?
Make it short.
Can you please rephrase or make your query?
The first question is, what are the challenges in investigating the Nd&Ps cases?
Challenges in investigation is the domain of the investigating agency. Anyone who would like to volunteer for this question? Challenges in investigation of the Nd&Ps cases.
Well, challenges, I will only say that if somebody's son or daughter is drug addict and I go and tell that parent that your child is drug addict, what the father reaction or mother reaction will be? They will start abusing me. You are just leveling allegations, false allegations against our son or daughter. They will never believe it. They will only believe it when he has crossed all the limits and he started taking money. He start stealing money from home itself for purchasing those drugs. Then they will realize it. Then they will come to you, otherwise they will not. Secondly, no witness will come forward. No person will come forward to inform the police that such and such person is indulging in drugs. Nobody. I think this is the biggest, and it is only their personal efforts that they get information that such and such person is indulging in such trade. Otherwise, nobody is going to give the information. This is what I can understand from my experience from the investigating officers. But if investigating officers themselves tell us what are the difficulties being faced by them, it will be better for the audience here. Thank you very much. Well, well, friend, very. Yes, you have.
Dear participants, sorry to interrupt you.
Very.
So please be specific.
Yes, a very interesting question you have put, that only peddlers are drug addicts, they are being convicted, and the kingpin is not being caught. This is the question. Kingpin is not being caught. Even in 500 crores, this seizure, I think the kingpin must not have been arrested so far. Whether, madam, kingpin has been arrested or only driver has been arrested? Peddler was arrested. So the question is, who is kingpin? Who is kingpin? He is a very influential person, I must say. I say in this house as academician, he is a very influential person, having very high ranks, and it is very difficult to put hand upon him, first. Second, no peddler will name who is the drug supplier. No drug peddler. You may ask him 50 questions, he will not give. The only thing is that you chase him, just to allow him to go, and from the person he takes the supply and the person to whom he gives the supply, both should be arrested. Then the chain will be broken. That supplier and that person for whom this was meant, they will give the names of the persons for whom they are working. This peddler, he never knows who is the kingpin. Even the second man will not know who is the kingpin. Third man will not know who is the kingpin. The kingpin will be known only for on the top, when you will arrest at least 10 persons in this sequence. So this is very difficult to arrest the kingpin, because he is a very respectable person, because he has the money. Friends, I may tell you, when I was a small kid, I was studying in the school. We have 2 persons in our village who were taking church. They were never, nobody gave their daughter to those persons, and they died issueless, without marriage. Marriage was not, so that was the morality of the people at that time. Today, even if a man is in smuggling, but he is rich, people go to his house and they say, okay, I offer my daughter in marriage for your son. So this is a change in our attitude. This is a change which has occurred during my lifetime at least. I know it for certain. Earlier, the people were, if there is a raid in the house of some person, income tax raid, I know in my village area, there was a raid of the income tax in one person's house. Everybody in the locality, they boycotted that family. No, this is a dishonest person. But today, people say, you come and have income tax raid in my house, because my status will be very high. He is a man whose house has been raided by the income tax officials. So that is a change in our attitude. So this change has come. So with this change, it is very difficult to arrest the kingpin. I have even pointed out many times who is the kingpin, where is the kingpin. So this is something we have to bear, but still we should try. Through the director of the Narcotic Control Bureau, we should move him that we believe that there is some kingpin, and we should allow this transit of the narcotic drug to another state or to another country, and then the kingpin should be arrested. Only then the kingpin can be arrested, otherwise it is very difficult. Section 50A has to be resorted to. Section 50A of the NDPS Act. That is a provision which we can to arrest the kingpin. Thank you. Section 59, it says failure of the officer in duty or his connivance at the contravention of the provisions of this act. Any officer on whom any duty has been imposed under this act. So section 47 imposes duty on the officer, and who ceases to or refuses to perform or withdraws himself from the duties of his office shall, unless he has obtained the express written permission of his official superior or has otherwise lawful excuse for so doing, be punishable with imprisonment for a term which may extend to 1 year or with fine or with both. So 1 year imprisonment or fine or both. So this is the provision 47. For 47, this for 59 is there. So we can proceed against him under section 59. Thank you. I could not understand the question. Who will? Who will take up the proceeding against that person? Against that person? Yes. Any officer under section 41 or 42 who are authorized under this act can take the action. But the only question is that whether it is within his knowledge that illegal cultivation has been done there. So that is something, it is very difficult, because forest area or the revenue area is so much that it is very difficult to pinpoint that it is for them. But the lower of staff, that a range officer or so the staff, lower staff, or revenue officer, patwari, etc., they can be hauled up, and if one case is registered, entire state will come, all the officers in the state will come forward and they will report illegal cultivation in the area. The purpose is that it should be destroyed. The purpose is all illegal cultivation should be destroyed as early as possible. That's the only way out. So if it is destroyed, our problem is solved. If it is not destroyed, problem will continue. But here, the problem is otherwise. In Manipur, it is less of cultivation, it is more of coming of the drugs from our neighboring country. That's the problem, like Punjab, Rajasthan, J&K, the same problem is there. It is coming from our neighboring country, and even drones are being used for sending this contraband to India. That is being used. Drones, even drones are being used there in Punjab and that area. Thank you.
Contraband is not ascertained, don't you think there will be, it will be adverse to the accused persons? Now, because now it is very important to look at the quantity of the contrabands that is seized as well. Thank you. This is an output, Your Honor.
I'm sorry, I couldn't get the first part of your question in full. Your voice was cracking up.
Sure. Ma'am, okay. Ma'am, the proviso of intermediate quantity, small quantity, commercial quantity has been enshrined for a reason under the NDPS Act, that we all know. I mean, based on that, convictions are also made, the sentences are also made. Now my question is, isn't it mandatory, isn't it important for the purity of the drug, the alleged drug seized, needs to be ascertained? Now, in many cases, and in many FSL reports also, what I've come through is that they have not provided, that is in context with the cases here in Manipur, they have not provided the purity of the alleged seized contrabands. Now that comes a very important question. Now in line with that, now the question of this Hira's case is that, will that case be adverse in certain aspects also? Because for an example I've mentioned, 50% and contraband seized, 50% is heroin, the other 50% is maida or flour. So now there's something, a loophole is there. So it's really important for the purity of the drugs to be ascertained. So give an outlook on this, ma'am. Thank you very much.
Indeed, I think that purity of the contraband seized needs to be ascertained, but the law declared by the Supreme Court is the law of the land. So harassing as a law as it stands today, declared by harassing, is that the offending and the non-offending, the neutral mix should also be considered. It's rather a regressive, my personal view, regressive law. The earlier law was E. Michael Ra's case, was that the offend neutral mix should not be considered. This is relevant for the contraband like codeine, which is primarily a prescription drug. And if following harassing, the entire bottle will be considered to assess the quantity. So, but we have to follow the Supreme Court decision. It's the law of the land. Purity, purity, this part, the result in the FSL report doesn't give the purity in respect of Manipur. But in other states, they give the purity. And when we examined the chemical expert, the chemical examiner, he said that one specific device, gas chromatography is not there, if I'm not wrong. Presently, only the color test is done, the reagent test is done, while to determine the quantity, to determine the purity, they need certain equipment or tool to assess the quantity, to purity, I mean. They said that it's not in their laboratory.
Well, friends, I will, on the lighter side, I will say that India is safe. We are safe only because adulterated narcotic drugs are being supplied to the addicts. Adulterated. It is more than 50% adulterated, so they are safe. Otherwise, if it is pure, there would have been devastation in our country. This is one thing. Secondly, I was in 2023, I was delivering lecture in Meghalaya. There the pictures were shown. What is the difficulty of investigating officers? This was a question. The picture was shown that the accused was so violent that she was giving kicks to the lady constables who were apprehending her. That was the position. Because when she needs drug, she becomes violent. Any accused will become violent when he is in need of the drug. So he becomes violent. So that is a major problem of the investigating officer, how to control that. In Meghalaya, they have shown the pictures, and they were so touching that how the police constables are arresting that lady. 4 ladies could not control that lady. That was the position. She was in such a condition, mental state. So that is the problem which are being faced by the investigating officers.
Thank you, participants.
Only one
Oh,
question.
okay.
Only one question.
Manipurida hangmana Manipurida pakhum pizarage ko. Faulty investigation hagira may be bona fide or malafide. It's adudi subject to kahini adudi hakta haibangam de koin on the face ta ko. Ado yamna patently malafide or hadi on the face ta man ba adugumba at the most aina taw thengna zabdang isa ai hija personal in the very start of my presentation in high hibado. Recovery was made. I won't mention the state Karamba police station or the Hijam roige. Huge quantity of contraband was recovered. Tata truck to that also based on a prior information. Pau bhangaga ko. Aduga the seizing authority, the seizing officer was a head constable. Head adu khang de ko mai lo do mamang dagi ngarang nahan gi na tesi case recent hadi 2000 something 2020 adwai case ni ko hai se. hari mamang 1980 haji sai hai ki ba gazette notification da 1989 da gi gazette notification leire aduda ASI gi rank ti ya de se leira baneba aduga adui matung ta investigation mayam pairaba police department ne ba ko adu thengnai adu aina tawgi bai in my on my part ain tawgi bai bo adu 42 compliance is mandatory aduga unempowered unauthorized officer na tawruba city it's fatal to the prosecution that's the law aduna accused to the discharged away ba ko have the at the stage of charge framing da adu do point out to defense na ado akoina tawba ba confiscation di tawna ba honare kind of the contract it's a different matter with regardless of the fate of the trial whether discharged acquittal or convicted vehicle or conveyance used in the transportation of the contraband is liable to confiscation or not have a CD court ki mandate it's a duty of the court to inquire into that matter ko adugi part to the taken I took up that part only aduga at the most aina tawba moi concerned SP DGP moi da si ko maina thokpano si very hadi moina asukuina case investigation contraband related matters da tawbala aga si khangde haba se yamna kono oi haba laitaba nate adugumba mayam thengnai ba ko adugi wane aduga prosecute tawbagi somna habiba adu karamba section da ai adudi point khangzade karamba which section of the NDPS faulty investigation tawbagi prosecute taw yai habado ayo gi mathakta investigation complaint file to your head section no which section specifically provides that oh I think Sir Rotha might want to add Sir si matang sida Sir Chume we all akhoi mayam se collective Chume every not just the law enforcement agency even the public mayam khudimag se akoi sigumba kono sida fight makta lo involve oi engage oi gadabane si Sir Rotha please
authorized city policy decision city kind of debate to we are in
Madam, Lanet Pem San, Madam, the section I have the 58 and 59 go to Sanda 58 ka 59 get the 59 and a Korean Sanda.
Punishment for vexatious entry, search, seizure, or arrest. Any person empowered under 42 or 43 or 44 who, without reasonable ground of suspicion, enters or searches or causes to be entered or searched any building, conveyance, or place vexatiously and unnecessarily, seizes the property of any person on the pretense of seizing or searching, have the abused or kanasi powers malafidely kanagum unnecessarily migi property to changuraga with the pretense of seizing or contraband changuraga adugumatugi liability fixed the one. Had they not prosecuting the IO or anyone? IO as in any false links I have do question dung is I do happen.
Madam 59, failure of officer in duty or his inconvenience at the contravention.
Mana abused or powers search unnecessarily adugi pretext changuraga tobagi provision ne sigidi. 59, failure of officer in duty or his connivance at the contravention of the provision of this act. Any officer on whom any duty has been imposed by or under this act and who ceases or refuses to perform or withdraws himself from the duties of his office unless he has obtained express written permission of his official superior or has other lawful excuse for so doing, be punishable with imprisonment for a term which may extend to 1 year or with fine or with both. Any officer on whom any duty has been imposed by or under this act or any person who has been given the custody of addict or any other person who has been charged with an offense under this act willfully aids in connives at the contravention of any provision of this act or any rule or under punishable the oi, but who will say proof hadisi mere suspicion diya dedana should be material should be there complainant kana oi do no complaint hadana hadi court kidi if formal complaint amdi dum change ba to proceed to act on the matter ado complainant kana oi do no ba the complaint amala adi obviously if offenses make out dum prosecute to biyaina ado ngasi babudadi I so far haven't come across any such complaint by anyone to prosecute any officer who has under this provision.
Question
excuse me, sir. Let it be the
last question for the session.
Okay. My name is Hon'ble. I'm Deputy Legal Aid Defense Counsel.
Oh, hi, sir.
My question is, now we have been discussing that accused was acquitted because of some technical issues. But let's say the defense counsel made a very aggressive defense, saying that no contraband item has been seized from me, that you have implanted on me, which resulted into a Mexican standoff in such a way that either the contraband item was with the accused person or was with the police officer. So let's say after going through all the trial, the court acquitted the accused person on the ground that there is a doubtful facts where the accused was given the benefit of doubt, saying that he is not in possession of the contraband items. So in such scenario, can the police officer be prosecuted for possessing the contraband items which he implanted on the accused person?
If the fact of implantation or false accusation is made out, I don't think there is, we can go with the prosecution.
Thank you.
So now we are at the end of the session. Before we close the sessions, so I take an opportunity to extend my heartfelt gratitude to respected Sir J.N. Barowalia for expertly moderating the second technical session, and special thanks also to respected Ma'am Mona Lisa Maivam and Ma'am Mangalevi for sharing their valuable insights on NDPS related subjects. And thank you everyone for coming. And now we formally close the today's session. Thank you everyone. So tomorrow, like, we have the another session also. So please come, like, before the scheduled time.
Go to the